premises which are presently being used as a quick commerce store. There are significant quantities of perishable items in this storage. Actually, our case is that the requirement of a prior notice under section 403 that has not been complied at all.
Deeply.
May I please, Your Lordship? I beg to mention item number 27. Yesterday, I have given the adjournment slip in regard to that.
Huh?
Item number 27. I have given the adjournment slip in regard to that.
Item number 27. Your name?
A. Banerjee.
Mr. A. Banerjee, learned counsel for the petitioner. What's the ground?
Leading counsel A. Das is out of station for medical treatment.
Submits that. Submits that the arguing counsel, Mr. A. Das, is presently out of station in connection with his medical ailments. In connection with the treatment, for receiving treatment in connection with his medical ailments. Accordingly, it is prayed that the matter be adjourned for
2 weeks.
3 weeks. So, prayer accepted. The petition stands adjourned for 3 weeks. The matter be not treated as parted or tied up matter with this bench any further. If you need to do it.
May I please, Your Lordship? And for a little accommodation, Lordship, item number 20, motion matter, Lordship. And can it be taken up after taking up the Lordship top of the list matter? I have another item, Lordship, urgent matter that is.
Have you informed the petition?
Yes, he is available here.
What item is that?
My Lord, item number 2, Lordship.
Go and do it.
Eviction matter, Lordship. We have made mention.
No, go do it.
Apply.
May I please, Your Lordship?
Mr. Das, you need not wait. I will first finish the top of the list items and then pass the order. Any of your junior be here. That will.
May it please, Your Lordship? Lordship, with the due consent of the other side, I beg to mention item number 19, Lordship. In this matter, it's a joint prayer, my lord. Can this matter be fixed anytime in the next week, my lord? What has happened is the reply which has been filed by the other side my lord, we don't have it as yet. And my lord,
On the prayer made by Mr. A. Fukan, learned standing counsel, JD,
my lord.
For an adjournment in the matter, not being objected to by Mr. H. Rama, learned counsel for the petitioner. Register to list this matter again after 2 weeks on a date.
Obliged.
May it please, Your Lordship? Lordship, I may be allowed to mention move a matter urgently tomorrow.
What is the urgency?
Urgency is that, my lord, I have recently opened a bar cum restaurant and through the virtue of IMFL on license, it has been temporarily closed illegally, violating rules order dated 29/5/2026.
Permitted.
Obliged.
Lordship, I have already filed a writ petition challenging a tender process, Your Lordship. There is some urgency. Can it be listed tomorrow, Your Lordship? You guess, Your Lordship.
Alligators, eh? No, delivery for alligator.
There is a possibility my case might become infructuous if it is not listed tomorrow, Your Lordship. That is why.
What's the issue?
Regarding tender process, there
I
are
don't
2
know. What
bidders
is-
selected, Your Lordship, in technical bid. I am one of them. The other bidder is not technically qualified. He has played fraud. That I can substantiate, Your Lordship. So if work order is issued to him, there is every possibility that work might get issued tomorrow.
Financial bids have been opened.
It was open, but it was not reflected online. Yes, uploaded online, Your Lordship. That is one of my grievance. Tomorrow, Your Lordship. Obliged.
May I please, Lordship? With the consent of other side, Lordship, I beg to mention item number 28, Lordship. I am on behalf of Mr. A. Das Gupta, Lordship. He is not feeling well today, Lordship. Kindly matter may be attended for 2 weeks, Lordship.
You're making a mention on behalf of?
Ashish Das Gupta, Lordship.
Why not present today?
He is not feeling well, Lordship.
A prayer is made on behalf of Mr. A. Das Gupta, learned senior counsel, on account of being indisposed. Also, have you informed the other side?
Yes, Lordship.
The prayer is made with due intimation with the consent of the respondents. Accordingly, register to list this after 3 weeks on a date to be.
Much obliged.
May it please, Your Lordship? Lordship, I beg to mention item number 22. Actually, I've got eczema in the eye. I'm not able to read anything, Your Lordship. So I need a week's accommodation, Lordship.
Ms. P. Borua, learned counsel for the respondents number 3, 4, and 5,
Yes, Your Lordship.
has submitted that she be granted an accommodation today on account of an eye problem suffered by her. Prayer is not objected to by Mr. M. Sharma, learned counsel for a petitioner. Accordingly, registry to list this matter again on
12th, your lordship. 12th is good, your lordship. I think 5 days I'll be over. It will be over.
15/6/2026.
Much obliged. Much obliged, your lordship.
My lord, Mr. A.R. Bhuya is on leg list. My lord, kindly take up his presence.
Thank you. Three matane. None appears for the petitioner. Registry to list this matter again after the on 14/7/2026. Yes, have you gone through that?
Yes, my lord, regarding delay part, my lord, I have, my lord, get one judgment from our High Court, my lord.
So otherwise your grievance is taken care of,
Yes.
but for the retrospective.
Yes, ma'am.
Okay, show me. Are you aware of the Supreme Court judgment in this connection from the state of Rajasthan?
No, my lord. My lord, I will be allowed to, my lord, read some para.
What do you want to say from this?
My lord, from my lord, para 20, my lord. Eh, May I read, my lord? Para 20. After the decision of the
Okay,
honorable,
that all are clear, but what about your delay?
regarding that, because my,
This is a different case altogether. Here the promotion was made.
Yeah.
But the regularization was not made. So the court said nothing doing. And in the facts of that case said promotion with effect from after retirement he has paid, but we will give you. But now, case of Dr. Amal Satpathy, Supreme Court,
yes, my lord. That is,
you have got your benefits. 97, show me. Costly
that,
delay by not only delay, latches are there.
yes, my lord. That delay, I have not explained.
You have not
and-
explained. So
and
forget it. You have
all-
got it now. We'll direct them to implement that order at the earliest. And you had placed an order on the last date.
Yes, my lord. One communication is also there, my lord.
What is the date? 15/5. No, no, I'm at
Yes, my lord, 15/5. To pay all the consequences.
Only there, my lord, in last line, on status of pension and pensionary benefits of the petitioner, my lord, they have only, my lord, seeking time.
Are you receiving pension?
No, my lord, only provisional pension.
Where is that speaking order? 13/5.
My lord, 13/5. Must be there in the file, or I can give one.
You had given him a copy.
Yes, my lord, I have given him.
You have gone through
Yes,
that.
yes.
Everything is fine there.
Yes, my lord, that part is okay, my lord.
We're closing it in line of this.
Yes, my lord.
But Mr. Sarkar and Sarkar, learned counsel for the petitioner, also heard Mr. D. Bora, learned
DSS of
standing counsel, DP Bora, learned standing counsel, Health and Family Welfare Department. The petitioner has instituted the present writ petition, praying for his retrospective promotion to the cadre of Senior Medical and Health Officer with effect from 12/4/1994 and or at least with effect from 31/3/1997 and thereafter as Subdivisional Medical and Health Officer from 22/1/2007 or at least with effect from 12/11/2007 by applying the principle of apostrophe next below rule. The petitioner for the purpose has presented a challenge to an order dated 21/5/2015 to a speaking order dated 21/5/2015 by which he was granted a retrospective promotion to the said cadres from the year 2006 and 2014 respectively. Also, the petitioner has further prayed for release of his pension and pensionary benefits accordingly. Also, the brief facts requisite for adjudication of the issues arising in the present petition is noticed as under. The petitioner was initially appointed as a medical and health officer -1 under Regulation 3F wide and notification dated 10/12/1983. Also, thereafter, the petitioner on being selected by the Assam Public Service Commission, he was regularly appointed as a medical and health officer, Roman 1 down, wide and order dated 10/7/1986. The petitioner continued in his services in such capacity. Also, the petitioner in the meanwhile also pursued higher studies on being granted permission for the same by the departmental authorities. The materials of it is projected in the petition that in the gradation list of medical and health officers -1, published in the year 1989, the name of the petitioner was not included therein. Being aggrieved, the petitioner had approached the respondent authorities by way of submission of representations. So, as the petitioner thereafter proceeded to undergo pursue further higher studies, the said aspect of the matter was not proceeded with by him, was not pursued by him. So thereafter, on resuming his services, the petitioner was wide notification dated 14/9/92, was posted at Gauhati Civil Hospital. Thereafter, the petitioner was wide order dated 29/10/98, transferred and posted as medical and health officer -1 to Bilatia BHC. The petitioner accordingly carried out the said transfer. The transfer as effected in respect of the petitions. So the petitioner was thereafter transferred and posted as medical and health officer to Gauhati Civil Hospital, Gauhati, wide and order dated 26/6/2000. So the delay on the part of the petitioner in joining at
Bilotia
PHC as ordered by wide notification dated 29/10/2098 was subsequently regularized by grant of leave on medical grounds to the petitioner wide and notification dated 19/6/2008. Also, the petitioner, by now having completed more than 25 years of service, his case not being considered for promotion to the next higher grade of senior medical and health officer, although such consideration being extended to persons junior to him and promoted to the said cadre, comma. The petitioner approached the respondent authorities, praying. Full stop. The respondent petitioner contends to have approached the respondent authorities. However, such approach of the petitioner had not resulted in his case also being extended with a due consideration for such promotion. Thereafter, persons junior to the petitioner and promoted to the rank of senior medical and health officer in the year 2007 came to be further considered for promotion to the rank of senior divisional medical officer, senior divisional medical officer, medical and health officer. And they, on their such selection, came to be promoted to the said cadre wide notification dated 24/5/2012. So it is seen that the petitioner had thereafter approached the respondent authorities formally by way of submission of a representation dated 10/7/2012, praying for his promotion to the cadre of to the next higher grade cadres. The said representation was further followed by reminders issued in this connection to the petition. In pursuance to the representation submitted by the petitioner, the case of the petitioner for promotion to the rank of senior medical officer, medical and health officer was considered, and wide notification dated 6/5/2013, the petitioner was promoted to the rank of senior medical and health officer, although with prospective effect. The petitioner assumed the charge of his promotional post. When did you retire?
My lord, 31st of May 2015, my lord.
Also. Thereafter, considering the prayers made by the petitioner in the matter, the respondent authorities proceeded to pass a speaking order dated 21/5/2015, and therein granted retrospective promotion to the petitioner to the rank of senior medical and health officer with effect from the date of his promotion of his immediate junior, Dr. Hiteshwar Gogoi, with effect from 6/2/2006 to 8/5/2013. Thereafter, the petitioner was further granted a retrospective promotion to the next higher grade of subdivisional medical and Roman and health officer with effect from 26/8/2014 to 31/5/2015. The petitioner thereafter retired from his services on reaching the age of superannuation with effect from 31/5/2015.
2015.
Being aggrieved by the non-consideration of his case for promotion with effect from 2007 to the rank of medical and health officer, and with effect from 2000 with effect from 1994 and to the cadre of subdivisional medical and health officer with effect from 2007, the petitioner has instituted the present petition. Mr. N. Sarkar, Learned Counsel for the petitioner, has fairly submitted that although the petitioner had made a prayer in the present petition for consideration of his case for promotion to the rank of senior medical and health officer with effect from 1994, and to the rank of subdivisional medical and health officer with effect from 22/1/2007, no explanation has been brought on record towards justifying the delay in approaching this court by way of instituting the present proceeding, praying for the said relief. It is submitted that the petitioner has also not brought on record any representations that may have been submitted by him in the matter, claiming the said relief. Also, having made the said submission, Mr. Sarkar submits that the order dated 21/5/2015 is erroneous inasmuch as there is a gap existing therein with regard to the promotion of the petitioner from the rank of senior medical and health officer to the rank of senior divisional medical and health officer. Also, he submits that the respondent authorities submits that the speaking order as furnished to him by the learned counsel for the respondent authorities, remedying the said defect existing in the speaking order dated 21/5/2015 has been perused by him, and the same is found to have redressed the grievance of the petitioner to the said extent. However, Mr. Sarkar submits that although the petitioner had superannuated from his services on 31/5/2015, the services, the pension and pensionary benefits of the petitioner have not been finalized till date, and he is only being extended with a provisional pension till date. Provisional DCRG you have got
Yes, I have been.
along with a provisional DCRG. Leave encashment, DCRG, along with leave encashment, GIS, etc. Yeah, have you got the GIS, leave encashment and all? Okay, but they can continue. A khali provisional pension and provisional DCRG. Mr. D.P. Bora, learned counsel for the petitioner, by submitting that the petitioners having instituted the present petition only in the year 2016, cannot be permitted to pray for grant of reliefs to him by way of promotion with retrospective effect from the year 1997, 1994 and 2007 to the posts of senior medical and health officer and subdivisional medical and health officer respectively. It is submitted that the said prayer of the petitioner is hit by the principles of delay and laches, inasmuch as no explanation has been brought on record to justify the said delay in approaching this court, praying for the said relief. Also, Mr. D.P. Bora has submitted that the promotion of the petitioner to the rank of senior medical and health officer, while a speaking order dated 13/5/2026 has now been effected with effect from 6/2/2006 to 28/5/2014. He submits that the promotion of the petitioner thereafter having already been effected from 26/8/2014 to 31/5/2015 to the rank of subdivisional medical and health officer, the petitioner would now be entitled to receive his pension and pensionary benefits at a higher rate, at a higher stage than what he would have so received prior to his service status. He would have received considering his service status prior to 21/5/2015. Accordingly, Mr. D.P. Bora submits that the present writ petition in view of the speaking order dated 21/5/2015, read with the subsequent speaking order dated 13/5/2016, 26B closed. That's it.
Yes, madam.
I've heard the learned counsel for the parties and also perused the materials available. The learned counsel for the petitioner having fairly considered that the prayer for the retrospective motion to the cadre of senior medical and health officer and subdivisional medical and health officer with effect from 1994 and 2007 respectively to be not pressed, to be not maintainable in view of the delay occasioning in approaching this court, making the said prayer, and in absence of any justification given about any reasons adduced for justifying the delay occasioning in approaching this court, praying for the said relief. Accordingly, the said prayer of the petitioner is not being considered by this court. The above being stated, this court finds that the petitioner, although was promoted to the rank of senior medical and health officer, while the notification dated 6/5/2013, such promotion was only with prospective effect. The petitioner having approached the respondent authorities praying for redressal of his grievance and for grievance with regard to non-consideration of his case for promotion with effect by maintaining parity with such promotion effected in respect of his juniors, the respondent authorities had considered the said prayer and while a speaking order dated 21/5/2015 granted promotions to the petitioner with retrospective effect to the cadres of so-and-so senior medical and health officer and subdivisional medical and health officer. The order, the operative portion of the speaking order dated 21/5/2015 being relevant is extracted here. A to A, page 95. A perusal of the said order would go to reveal that the petitioner has now been granted promotion with retrospective effect, that is, with effect from 6/2/2006. His such promotion was granted till 8/5/2013. The said promotion being now granted with retrospective effect, the promotion, the said promotion of the petitioner to the cadre of senior medical and health officer being now granted with effect from 6/2, retrospectively with effect from 6/2. The petitioner is to be now held to be an incumbent in the cadre of senior medical health officer with effect from 6/2/2006, and his pay and allowances in the said post would now be required to be fixed with effect from 6/2/2006. The petition after the speaking order does not provide for any does not provide as to the manner in which the services of the petitioner after 8/5/2013 is to be so construed. The same, in all probability, was on account of the fact that the petitioner was already promoted to the post of senior medical and health officer -1 with effect from -1 senior medical and health officer with effect from 8/5/6/5/2013, and he had in all probability joined the said promotional post with effect from 9/5/2013. Accordingly, in the speaking order, his promotion was made effective from 6/2/2006 till 8/5/2013. The said speaking order also reveals, perusal of the said speaking order, further perusal of the said speaking order also reveals that the petitioner was with effect from 26/8/2014 till the date with effect from 26/8/2014 granted further retrospective promotion to the rank of subdivisional medical and health officer. The said promotion is found to have been so granted to the petitioner till 31/5/2015. That is the date on which he had attained. He had retired from his services on attaining the age of superannuation. Also, the ambiguity existing in the order dated 21/5/2015 to the extent that the same had only promoted the petitioner to the cadre of senior medical and health officer till 8/5/2013 has been further clarified by a subsequent speaking order dated 13/5/2026 passed by the respondent authorities. By the said speaking order dated 13/5/2026, the retrospective promotion granted in respect of the petitioner to the rank of senior medical and health officer has now been deemed to be so construed to have been effected with effect from 6/2/2006 to 25/8/2014 instead of the earlier grant of promotion with effect from 6/2/2006 to 8/5/2000. It has further stipulated therein that the pension and pensionary benefits as well as the areas of pay in respect of the petition would now be considered by reckoning the retrospective promotions granted to him. So, on a perusal of the speaking order dated 13/5/2026, this court is of the considered view that the retrospective promotions effected in respect of the petitioner has now been to the cadres of senior medical and health officer and to the cadre of senior subdivisional medical and health officer has now been regularized. So, accordingly, the petitioner is now required to be treated to be an incumbent in the cadre of senior medical and health officer as of 6/2/2006, and accordingly, it is directed that the pay and allowances of the petitioner as on 6/2/2006 be so fixed. Thereafter, the areas of pay receivable by the petitioner in the cadre of senior medical and health officer with effect from 6/2/2006 till 28/5/2014 be computed by granting to the petitioner his annual increments as well as the revision of pay occasioning a revision of pay coming into force, if any, during the said period. Thereafter, the pay of the petitioner be fixed in the cadre of senior divisional medical and health officer as of 26/8/2014, and the pay of the petitioner be similarly computed till the date of his superannuation, that is till 31/5/2015. So, the areas of pay working out on account of the fixation of the pay of the petitioner in the manner directed herein above be released to the petitioner within a period of 3 months from the date of receipt of a certified copy of this order. The pay of the petitioner now being determined as of 31/5/2015, that is the date of his superannuation. The said exercise being carried out, the pay of the petitioner on 31/5/2015 being determined, the pension and pensionary benefits due to the petitioner be now processed and a proposal in this connection be submitted to the office of the Accountant General within a period of 3 months. Within a period of 1 month after release of the salaries of the petition. The Office of the Accountant General, on receipt of the proposal from the department in pertaining to the authorization of pension and pensionary benefits to the petitioner, shall further process the same, and within a period of 1 month from such receipt, for 2 months from the date of receipt of such proposal, authorize to the petitioner his due pension and pensionary benefits. So, while authorizing to the petitioner his pension and pensionary benefits, the provisional pension and other pensionary benefits already drawn by the petitioner shall be also accounted for, and the amounts involved deducted before releasing to the petitioner the areas of his pension and pensionary benefits. With the above observations and directions, the present writ petition stands disposed of.
Right.
Foro, Learned Standing Council, AG, Assam, appearing for the responsibilities.
My lord, only one thing, pension, pensionary benefits and other allowances which include my lord rent.
That will come in your pay. Pay and allowances koi divide.
PLR. All like that.
When we say pay, it includes everything. You're in service. Line the respondents in the subsequent speaking order dated 13/5/2026, having held that the petitioner would be entitled to his salaries for the period for against the post of subdivisional senior medical and health officer and subdivisional medical and health officer on account of the retrospective promotions granted to the petitioner. The petitioner is to be held to have discharged his duties against the said posts, and accordingly he would be entitled to all consequential benefits of pay and allowances for the said period. Sometimes it just slips. Like that, if you point out, we can find. Yes.
Lordship has directed me to prepare the list. He has provided the list of the employees, seasonal employees, but there is a difficulty because in the list there is CPF account number and other service details, but there is no mention of father's name or etc. And multiple person with the same name in the list, as well as the petition also. So it is very difficult to identify. So, Lordship, I pray that if Lordship give me some time, if petitioners can give me their CPF account number,
Okay.
then I can identify.
Okay. The prayer of the Learned Council for the petition registry to list this matter again on 16/7/2026 for further hearing.
Much obliged.
Mr. Kulta. I'll go into it. Mr. Das will take me in. But they tell me one thing. Whether the authority who had issued the show cause, who had initiated the departmental proceeding,
Yes.
was also a witness?
No.
Huh?
Witness was Mr. S. Ghosh, Senior Assistant Manager. Charge sheet issued by Mr. Babul Soikia, Superintendent. Lordship, I will show from the record, Lordship, I can place that record, Lordship. Letter of dismissal signed by Mr. Sam Masood, Senior Manager. All different person.
All different.
All different. If Lordship,
So the person who had
the records, Lordship.
No, you tell me. You are my record. You tell me. So all are different persons.
All are different.
And that whether that inquired the proceeding was fair or not, that was gone into by the.
In terms of the Ludbut Singh case, Lordship, the management in their written statement that they have taken this plea, Lordship. Before entering into the merit of the case, adduce the lordship, yes,
Evidence that
evidence.
was proved.
Proof, lordship.
Then only the evidence was.
Yes.
Yes, Mr. Das.
Milord, it is an ex parte order, Milord. The ex parte order passed by the Learned Labour Court, Milord.
You did not participate. You got notice.
Actually, what happened, Milord?
That facade that you have created in the repetition, that it was a union which was taking it up. The man was not there. The man was only victimized because he was of a minority union.
Yes.
But what do you say about the fairness? That is there a stay order here?
Actually, what happened, Milord? The advocate of the union expired, Milord.
P.N. Sharma, sir. He expired.
Ah.
What do you say on that?
Their
That's
plea,
a point
yes, lordship. Their plea in this regard, lordship, paragraph 40
of the
Paragraph-
repetition.
of the repetition. Paragraph 40.
I'm just trying to understand,
Yes,
Mr. Das, what it is.
That
We'll
the
give
petition-
you details. No.
That the petitioner begs to state that
14.
that the petitioner begs to state that after date of their counsel, they could not take steps to adduce evidence and argue their case before the court. The Learned Labour Court, ignoring the facts of the case, date of counsel of the workman's side, did not take steps to issue notice to the workman regarding the continuation of the proceeding. And before the workman could take steps to engage new counsel, the Learned Labour Court proceeded the case of ex parte. Lordship, may I kindly take up the LCR, Lordship.
You tell me.
No, Lordship, because page 9, Lordship, of the
What is
LCR.
it? Tell me. Just
Fresh notice was issued
Hmm.
on 3/8/10,
the
AD card
petitioner.
return after service.
to the petitioner.
Yes, to the, because the case
Whoever
was,
was
Yes,
conducting the
concerned.
proceeding.
the AD card return after service, 3/8/2010, Lordship.
Yes, Mr. Das.
In this case, Milord,
You give me the broad areas of challenge.
there
What are the grounds of challenge? How many grounds?
the number one, Milord,
Huh.
there was a incident occurred.
No, we'll come to that. What are the grounds? No notice, fairness of inquiry, ex parte, all those things. What are the grounds you will be
Yes, Milord. First,
breaking it
ground
up?
that they suspended 11 workers. 11 workers. After that, they withdraw the suspension order against 8 workers. And they single out these 3 workmen and proceeded against these 3 workmen. Because there are 2 unions, that is one was SAMS and one is a new union, which was our union was a new union. And the SAMS is the recognized union of the manager. So out of 11 suspended workers, they single out these 3 workmen who are not member of SAMS. It is a clear discrimination, Milord. Out of 11, they suspended 11 workers. But they unilaterally they withdraw the suspension order against 8 workmen. As because they were all member of SAMS. And the whole incident that occurred due to regarding payment of bonus, it was created by the SAMS. Our union was never involved in that case, But taking advantage of this situation, the management victimized these 3 workmen.
The reference was in connection with one workman. 3 workmen.
3 workmen.
Meghnad, Vaneshwar and Tilak.
The other 2 laws, paragraph 7, they have stated. They have already stated.
Paragraph 7 of the, what is the fate of that other 2?
During the pendency of the case, 2 workmen, Meghnad Kumar and Vaneshwar Rao, due to their good financial problems, submitted resignation and settled their dispute.
2 workmen, Milord, they surrendered, Milord, due to their financial constraint, due to their poor conditions. They submitted resignation and accepted the full and final settlement. And the only workers remained this Tilak Prasad. The management terminated the service, holding that also an ex parte domestic inquiry.
Now, what do you say about the award? What is the grounds for challenge of the award?
The award is that number one, it is an expert award.
But the ex parte, there were notices issued to you. You did not respond.
Notice has issued, but what happened in the garden, my lord? Notice gone there, garden, someone might have received, but
That
not
cannot be a ground. That
Yeah.
cannot be a ground.
go to the office of the garden management. They did not, they are not aware of this, my lord. Aware of that notice, my lord.
But your union, Assam Samrik
Yes, my lord.
Samrik Sangha, they have not come up and said that this notices because they were pursuing this matter on your behalf. It is here also. Why the
Because now,
Sangha had
if
not-
they would have received that notice,
No, why did the Sangha not proceed with the matter in the manner required?
my lord,
The Sangha
yes,
is known to be a is known to be an entity who is in know of the legal intricacies.
that's true, my lord. That-
Okay, experte.
And now already, my lord, that worker has already attended the retirement age, my lord. Whoever has been, my lord. There is no
What
question
is
of-
your submissions on experte?
my lord.
What is your submissions on experte order? Why is it bad?
Sub-
I'll have to write your submissions. What are your submissions on that?
The expert, my lord, because of our advocate expired, my lord. Who is, they
Your
got the
case is no
information-
notice. No notice was received
Yes,
from the court. Any decision?
the union already submitted their written statement, additional written statement, my lord. They were not, it is not that they are not interested in this case. They are very much interested.
Any decision on this point? Any decision on this point?
Regarding, my lord,
This issue? This issue, any decision of the court, this court, Supreme Court?
wait. No, there is no, no, I have not tried any decision, my lord.
Then on merits, what do you have to say?
Merit,
This is on technicality. Merits, what do you have to say?
yes, merit, my lord. They hold the inquiry, expert inquiry, domestic inquiry. No opportunity was given to the workman, my lord.
In the domestic inquiry?
Yes.
Yes, only this much. Anything more?
No opportunity was given, my lord.
The records of the inquiry, domestic inquiry, Mr. Kulta was exhibited and proved in the before the tribunal?
Yes,
Labor
Lordship.
court?
Yes, Lordship.
Okay.
And
The statement of the employees are there, taken in the,
Lordship, in the award also, Lordship, regarding the domestic, the learned senior friend has stated that no opportunity was granted. Lordship, paragraph 7 of the judgment, piece 51. It's demonstrated that he has participated in the and cross-examined the management witness also.
okay. Then Mr. Das, next. Next point.
Yeah, yes. Now, my lord, already he has attended exam days, my lord. Only the question of regarding payment of full and final settlement, my lord, and the back wages. There is no question of reinstatement, my lord. That is why I proposed for a mediation settlement, my lord.
Anything more?
Yes.
This much?
A mediation settlement is so that the workman could have get
That
this.
if he agrees only, mediation. With his body language, I don't think so he's agreeing. But with the sketchy things, what relief can I give you? With the sketchy, submissions of yours, how can
Really?
I give you any relief?
Relief.
Expertly. If I find from the records, notices were issued. That's the end of the matter.
Notice has not
With
received.
regard to the merit, whether opportunity was given to you to defend your case, I find from the records while pursuing that yes, you had cross-examined the witnesses, you had done everything. That's the end of the matter.
There were three workmen, there only one, in one case there was a workman attended, but the other two, no notice was served.
Other two means you are making this prayer on behalf of which workman?
Tilak Tosa, Miller.
Tilak?
Tilak Tosa, yes.
Tilak Tosa. Did
Yes.
Tilak Tosa make cross-examination?
Yes.
Then
Yes.
other two, we are not concerned because they are already out. They have already settled the matter.
Tilak Tosa attended, but no, that domestic inquiry was not proper. That domestic inquiry conducted against him
Show me why it is not proper.
because no opportunity was given to him.
You say he had cross-examined also.
No cross-examination, my lord.
Okay,
Yeah.
show from the records.
Yes.
District inquiry, the fairness is that he must be given all documents. He must be given an opportunity to cross-examine the witnesses. So if documents have been given, cross-examination done, that's
Lord, a garden worker, my lord, how alone he can contest, my lord.
a different. Have you taken that plea? Have you taken that plea before the management that I don't understand anything, so give me an assistance? Naturally, some assistant, defense assistant might have been there. Was there any defense assistant, Mr. Kulta? In the demo
Presenting
domestic?
officer was there.
Huh?
Presenting officer was there.
No. For him,
A presenting officer of
No,
management
he
was
himself, Lordship.
he himself.
there.
Was he given an opportunity to get a defense assistant?
Yes, Lordship. He has cross-examined, Lordship.
No. Was he provided a defense assistant? Or the union was there? Some representative of the union was there?
He has made this statement before the domestic inquiry.
He submitted his Lordship written statement also, written explanation. Accordingly, he participated in the prosecution.
No, just where is his examination?
Yes,
You have the examination of the petitioner.
Yes.
Petitioner means Tilak Tosa. Mr. Das, with regard to the other two, you have made a categorical statement that you are not
No, other two I have not.
pursuing. Only with Tilak Tosa, this.
That's all. Other two already received their dues, my lord. His full and final payment may be made, my lord, gratuity, provident fund, bonus, etc. The allegations raised against them, my lord, are blatantly false, my lord.
Where is your written statement? Where is your that application? You're pleading before the labor court?
There are hundreds of workers assembled there. There is a police firing. One worker died. The management singled out these three workmen because of their union activities.
Where is your pleading before the tribunal, before the labor court?
We have submitted our WS, my lord.
Where is that?
From the search sheet. issued by the management to the three workmen, all are same, similar. And Miller, their allegation is that they have manhandled the manager. They have assaulted other workers, but there is no police case, Miller. There is no criminal case against them. If the manager was manhandled, then there should be a police case, Miller. There should be a criminal. There is no police case.
Page 42 is your written statement. Nothing perfunctory, nothing is here in page 42. No plea.
Yeah.
Statement is there. Whether he was asked that, whether he wanted a defense assistant and all. Any person,
Exhibit 13 to.
any personal of the, any office bearer of the union was there?
Union was.
Assam.
Whole problem was raised because of the
Sangrami
bonus, Miller.
Shramik Hongko. The domestic inquiry, they represented by the Hongo.
No. Nobody was allowed to defend himself.
Yes, anything more, Mr.? Anything more?
Our only
Anything-
grievance is that, Miller, at this result, as I have already retired, Miller, there is no question of
No,
reinstatement.
your retirement will be of inconsequential.
my-
We'll have to get away with the order of 2010.
Yes, Miller.
When did you retire? You would have
I-
attained the age of superannuation otherwise.
4 years back, Miller. Only full and final settlement, that is gratuity, bonus, provident fund, etc., which are all are pending.
Now, if you are dismissed, if we uphold the dismissal, say, then what benefit would we be entitled to?
Benefit, that is back wages.
No, if we uphold your, say, your dismissal, let's say the dismissal was okay,
Yes.
correct, legal, valid,
Then I have gratuity, Miller.
you'll get gratuity. That has not been given to you till now. Yes, Mr. Kolta, why the gratuity amount has not been released? Because two situations. If we direct for his reinstatement, then the back wages, this, that, everything will come. Now, if that is one situation, we'll pass orders. Then he is retired, he'll get all the retirement. Three situations here. Two, he along with two others were dismissed. Proceedings were there. With regard to the other two, they having approached you, submitted a letter of resignation, you had given them the benefits. The petitioner accordingly after his dismissal also submitted a resignation, but you did not act on that. What are the benefits given to the other two? Because they are three on the same level.
Yes, sir.
So what are the benefits given to the other two?
That I have to take instruction.
You get it? So at least that parity we can direct for maintaining with the petitioner.
Otherwise, Lordship,
No,
it shows that-
otherwise, departmental inquiry, fairness, everything
yes,
upheld with regard to 3. Right? Now, you can't make a distinction between these 3. They'll have to be treated at par. All are dismissed employees. Right? Other 2, according to their statement, because they submitted a resignation. The petitioner has also submitted a resignation. After that, that is there in your written statement. Third situation, okay, we hold because of the fairness of Mr. Kolita, the inquiry will not mandate any interference. Still, what are the benefits he will be entitled? When can you get it? Next week?
only Lordship 9 and 11, I have some personal difficulty. I am in the court,
16.
Lordship, because 2 part matters
16.
there. Yes,
But the learner counsel for the parties at some length. This court has queried, had raised a query with Mr. K. Kolita, learned counsel appearing for the respondent management as to the benefits that were extended to the 2 other co-delinquents who were involved in the departmental proceedings in domestic inquiry instituted in the matter by the management and who were also involved before in the proceedings before the labor court. Mr. Kolta submits that he for labor court. However, the other 2 delinquents, after being imposed with the penalty of dismissal from service, had approached the respondent authorities and the management had approached the management and the management. Where was that statement here in para?
para 7 of the petition. It's their contention, Lordship.
Settled, submitted resignation, approached the management and submitted a resignation. Thereafter, the management released to them their service benefits.
It's their contention, Lordship.
The petitioner is contented to have also submitted a similar resignation, but the benefits as extended to the 2 co-delinquents were not extended to the petitioner. Mr. Kulta submits that he will receive instructions with regard to the veracity of the said claim made by the petitioner in the petition, and in the event any such benefits have been released to the co-delinquents, the exact nature of the benefits so released would be placed before. Mr. Kulta shall further receive instructions that in the event the award is upheld by this court, the petitioner now being required to be treated as a dismissed employee, the benefits he would receive under such circumstance. As agreed to by the learned counsel for the parties, raised free to list this matter again on 16/18 when? 16th or 18th
I have
when?
personal difficulty on 9 and 8.
16? 6/2026.
Hello.
Thereafter, if we are required to go through the records, we'll book. Get me this. We'll see, Mr. Das, what can we do? We'll see what we can do.
Yes, yes.
Yeah, Bureaus. Lordship, in this situation, I'm challenging award dated 12/10/2018, my lord, whereby reference was
Where is the award?
possible find the award in page 166. Labor code award by this award, my lord, reference was allowed in favor of the government. My lord.
The domestic inquiry was found to be not fair.
Not exactly, my lord. This is not a domestic inquiry. It was a departmental proceeding, my lord, because petitioner company is a government of Assam undertaking. And accordingly, 1964 rule, my lord, Assam Services
It's been adopted.
adopted, my lord.
Where is your material to show that it is?
Lordship, that met in and proceeding was inquiry proceeding was
Where is
conducted.
the show cause?
Lordship will find the show cause, my lord. With regard to petitioner respondent 1 at page 54, my lord, and petitioner respondent 266 and respondent 389, my lord. 54, my lord.
He was a regular employee.
Lordship.
Have you challenged the reference?
Initially, petition was filed before the labor court, my lord, that perhaps this proceeding under that was rejected. Thereafter, we proceeded with the
So now that you have
Lordship.
done that, whether you can question that now?
Lordship, in this case, entire case was decided on the alleged ground of impropriety of procedural impropriety. That was silenced.
Procedural impropriety in conduct of the domestic.
Lordship, basically, that was a plea taken by the workman side, Milan, that being a company, this rule is not applicable, and that was accepted by the labor court. Lordship will find it page 25, Miller, paragraph 25 of 182, Miller. That admittedly, also have you got it? Admittedly, the corporation, the Assam government of Authorised, therefore rule is not applicable.
Okay, fine. Where is your contention that this rule was adopted by you?
Lordship,
This rule cannot be directly applicable.
Lordship,
This has to be adopted.
Lordship.
Where is the adoption?
Also, even Lordship will find in our written statement as well as evidence that was categorically.
But you will have to have a board resolution to that effect.
Lordship,
You can't just say that we have adopted.
Lordship. So normally, even in the High Court also, there is a numbers of cases, Milord, decided by this honorable court regarding that mass of. I have mentioned in my.
No, give me the citations. That is what the matter was fixed today. Mr. Monta would give
Lordship,
the.
that actually, Lordship, in the other day, Milord, my entire silence is in different point of view, Milord. In other day, Milord, Lordship, honorable court, Milord, point out regarding the ruling regarding procedural fairness of labor court jurisdiction, Milord. That is the copper engineering, Milord.
See, when a domestic inquiry is held,
yes, Milord.
The management has to establish before the inquiry officer, before the labor court, that the domestic inquiry was fair.
Lordship.
So that was taken up as a preliminary issue.
Lordship.
Was it taken up here? Was it established?
No, there is no preliminary issue, and only.
Have you established before the tribunal?
Yes, entire record was produced.
Exhibited?
Yes, Milord. Entire record was produced, and additionally,
inquiry officer was examined.
Three witnesses was also.
Who are the witnesses?
There's one on management side, one DW1, and inquiry officer, and another witness, Milord. Lawsuit will find it the cross-examination of that part, Milord, in 141, Milord. 141. Even in cross-examination, Milord, these are the management witness course in examination, and 158 is the workman purpose.
No, where is this adoption of the rule thing?
Lordship, I have this categorically stated in my writ petition as well as.
No, writ petition will not do, because that tribunal has taken a plea, drawn a conclusion.
Only plea made by workman side.
No, where is your material to show that the rules were actually applicable? Where is your evidence to that effect?
Lordship, that. Very milord, I have to.
On the prayer of Mr. M. Monto, learned counsel, for the petition registered to list this matter again on 16/7/2026. In the meanwhile, Mr. Monto shall, on the next date of listing, the Monto shall place before this court the relevant decisions in support of the submissions made by him. Mr. Monto shall also apprise this court as to whether the provisions of the Assam Services bracket Discipline and Appeal Rules 1960 was adopted by the petitioner corporation. Adoption will not do. You will have to show that you had demonstrated that before the tribunal, before delivery.
But in cross-examination or evidence, that was a question put before the court, and that's what also.
We'll see, you prepare. We will take up the provincialization part first. Or the other one first. Which one you want to take up?
My lord, the 8 first. My lordships, other day, my lord, said that it can be sent before the tribunal. But before that, my lord, I want to take your lordship to certain.
No, tribunal is with, if you want to go.
My lord.
Because if I dismiss this case here, then the only opportunity to you is to file an appeal. If you want to have this matter examined by way of evidences, then you will have to go before the tribunal. That's all.
Your lordship is very right.
Yes.
In terms of that Abdul Ghafoor. My lord, your lordship, I just would like to take your lordship at page 51. This is, my lord, the details, particulars of non-teaching staff, PHB college, within bracket, your lordship will find science table. And petitioner is Sanjeev Das, is number 1. His date of joining is 31/7/2008. And the respondent number 2 is placed on serial number 2, Ajit Bhuya. He was appointed on 1/8/2009. I am almost more or less 1 year senior to him. Then, my lord, I will take your lordship to page 52. Here your lordship will find statement showing the eligibility of post and persons eligible for provincialization of services as per Assam Venture Educational Institution Provincialization of Services Act 2011 and amended 2012 in respect of Degree College of Assam. Now here you also will find serial number 2, stream shown as science. And at serial number 10, the respondent number 6 name is reflected there, showing that he is qualified. Then, my lord, your lordship may look at page 54. serial number 7, Sanjeev Das, has been shown as disqualified in the right-hand column, my lord. From the bottom, page 54. Your lordship will find against art stream. Now, in the advertisement as well as in the appointment letter, it was never shown whether Mr. Petitioner as well as respondent number 6, whether they were art stream or in the science stream. It is a junior law divisional accountant. So first time we could come to know I'm disqualified on the terms that I'm against the art stream. Now, this is the factual position, my lord. And your lordship has seen there are so many writ petition has been filed, and then it went to the Director of Higher Education, and they, some point of time, they have passed some order in our favor. And against that, the other side filed a writ petition. That was, the director's decision was set aside. Now, the main question would be, my lord, whether it is a LDA, whether he is in the science stream or in the art stream, it ought to have been from the date of the appointment. Also from the date of advertisement, your lordship will find there are no indication in the advertisement that whether it is an art stream or in the science stream. Even in the appointment letter of both the petitioner as well as respondent number 6, no indication whether they were under the art stream or in the science stream. Now, while scrutinizing it, my lord, they have shown that in the, as I have shown in the page 51, that it is in the science stream, and the petition number 1 and the respondent number 6 has been shown that I am appointed in the earlier point of time. So in that factual background, my lord, I just like to say that where from they get that I was in the art stream. My lord, they did not indicate in the record also that I am in the art stream and I was not selected for that purpose. It was just shown in the page 54, as your lordship has seen. I am disqualified against the art stream only. In the short point, my lord, I just thought to take your lordships into consideration. Now, the lordship may say that we did not file a writ appeal against the order passed by the learned single judge. That is a question to be, my lord, record. Now, in those circumstances, my lord, your lordship is right to say that in terms of Gafur's judgment, that to let him get a chance being there.
Who is holding the post today?
My lord, the respondent 6.
Is holding. This controversial things, I'll tell you another point which is against this quotes, just to clear.
Right.
You come to page 87. You say that in your advertisement and in your appointment, there is no reference that this is made against arts or science stream.
Yes.
You come to page 87, that's a part of the affidavit filed by the college authorities.
This is the resolution, my lord.
Resolution you will find. It's a resolution of 9/7/2009.
Page 87.
87.
My lord, it starts from page 7.
Come to page 89. 1, 2, 3, 4, 5 lines.
Yes.
In the meeting, it is
also
also
opined by the members that the grade 3 employees of for shortage in science stream and the grade 4 employee library assistant having knowledge in electricals would be fruitful.
So then the advertisement comes at page 97. So this advertisement, when you read it along with the resolution, it's for the science stream. And there is a further resolution at page 99.
Yes,
Down below in today's meeting.
yes.
100.
Yes,
Yes.
third column.
In today's
Ninth
meeting,
page.
the appointment of newly appointed grade 3 employee, the Ajit Bhuya science stream has been unanimously approved. Lord, can I take your lordship to page 39, the advertisement which, in terms of which I applied?
There is nothing there.
Yes, those things are not there.
Not
You'll-
there, but
whether it is science,
but the in respect of respond number 9, 6, sorry, there is a resolution both prior to his appointment and after his appointment, wherein it is science.
Then subsequently, my lord, they have made. that.
And this court, if we come to the earlier directions at page 59,
Yes,
so this is the exercise, the matter was remanded back. And therein itself, there was a plea taken at page 58, down below, by the learned counsel for the respond number 5, that is today's respond number 6. Science stream, the respond number 5 was appointed as LD assistant and laboratory assistant in the science stream of the college. He submits that so-and-so was appointed so-and-so. He submits that not been appointed so-and-so. Petitioner, art stream. So this is the issue which was sent back for consideration by this court. The matter was then placed before the district level scrutiny committee.
yes.
Now, page 64, that issue as to whether both of you belong to the same stream was
Yes.
not gone into.
Ultimately, this was set aside.
This was then rightly set aside by this court. On a different point, wherein it said that the act is no longer there.
Yes, on that point it
So
was.
from that point of view, that is gone. Then you come up before this court and you withdraw that writ petition.
At page 71.
So you will have to now first establish that yes, my appointment, initial appointment was in the science stream, not the art stream. Now from these materials, we are not in a position to draw that conclusion. Rather, we are in a materials before us in an affidavit, which is not disputed by you. It is evident that the respondent was appointed against this side. So this affidavit by the college authorities is not countered by way of filing an reply.
Yes, your lordship is very right, Milan, but then initial advertisement and the appointment.
Now that is in tuck. It's a gray area.
Yes,
And that can be resolved only by you adducing evidence, maybe of people at that point of time who were there, bringing in contemporaneous records. Because for him, it is very simple now. See, my appointment is signed.
I understand, Milan.
So be in a jurisdiction, we can't go beyond.
Right, very right.
And this is not disputed by you. You have not countered that.
Therefore, my lord, I understand.
So, Mr. Doctor, if you agree, we'll permit you to withdraw this. Grant you liberty to approach the tribunal and make your submission. Until that time, the respondent number 6 should not be disturbed. But while you go there, if you want to challenge his appointment, make him a party.
Yes.
Heard Mr. S. Dr. Leonard Senior Counsel, assisted by Mr. S. Dr. Leonard Counsel for the petitioner. Also heard Mr. S. Das Leonard Senior Leonard Standing Counsel, Higher Education Department, appearing for the respondents number 1 and 2. Also heard Mr. P. Hazurika Leonard Counsel representing the
Respondent 3 and 4.
respondents number 3 and 4. Mr. Comment, who is there for comment? Learned Counsel appears for respondent number 5. Mr. N. Bora, Learned Counsel, is present, appears for respondent number 6. Mr. S. Dr. Learned Senior Counsel, after having attempted to argue the matter at some length, in view of the deliberations that have taken place during the course of the hearing, submits that he be permitted to withdraw the present writ petition with liberty to move before the jurisdictional educational tribunal for establishing the right of the petitioner for having his services provincialized. Also, the prayer made by Mr. As Dr. Learned Senior Counsel is not objected to by the Learned Counsel for the respondents. Accordingly, the petitioner is permitted to withdraw the present writ petition with liberty to approach the jurisdictional tribunal also, in the event of the institution of any such proceeding before the educational tribunal within a period of 1 month from today by the petitioner, from a question of delay arises, the learned tribunal shall, while considering the application for condonation of such delay, if any, shall consider the fact that the issue involved, that the petitioner was bona fidely pursuing the matter before this court. So the application for delay, condonation of delay, be accordingly considered. Also, the petitioner, while instituting, in the event of instituting the proceedings before the educational tribunal, shall include therein, shall implement therein the college authorities as well as the respondent number 6 hearing. So, with the above.
May I point out that order dated 3/9/2024 passed in the IA 2683.
2683.
Yes, 2683. There is a direction not to disturb the petitioner.
The
3/9/2024.
IA number?
IA number 2683 of 2024.
Order detail?
39 3/9/24. And a copy of this order.
No.
Yes.
That is already, that order is not there.
No, my lord.
That order was closed. That
My lord.
petition was closed on the prayer of Mr. Doctor.
Yes, my lord. That will be clear.
6/12/24. It is submitted by Mr. Doctor and Senior Counsel for the applicant that since the service has been effected on all the respondents, the purpose of filing the present application has been served. And therefore, the application may be disposed of. In view of the submission made by so-and-so, the learned counsel for the applicant, the IA stands disposed.
But that clarification may I pray it. It may disturb.
Mr. P. Hazurika, learned counsel for the petitioner.
Not my lord.
For the
College
respondent number 3 and 4 has submitted that interim direction was passed by this court in interlocutory application by order dated 3/9/2022 to not house the services to not oust the petitioner from his services in the college. Accordingly, he prays that the said order be vacated. Court has perused the records and finds that I bracketed C number 2683/2024. Oh, no. Also finds that the said order, although the IA number so and so was vacated, was disposed of by order dated 6/12/2024. This court an order dated 6/12/2024 passed in the present proceedings had directed that the direction not to oust the petition as passed in the said interlocutory application shall remain in force till further orders of this court. As the present petition has been disposed of and the petitioner and the matter and as prayed for by the petitioner and the petitioner being permitted to withdraw the petitioner being permitted to withdraw the present petition with liberty to approach the jurisdictional education tribunal for redressal of his grievances, this court is of the considered view that the order dated 3/9/2024 as continued by this court wide order dated 6/12/2024 need not be continued any further and the same stands vacated. The petitioner is at liberty to file appropriate application before the educational tribunal for protection of his services.
I'm obliged.
No, till the filing of the appeal, my lord, we may be protected.
No, my
Don't do anything till that day. You will ensure.
Yes, I'll instruct.
And this is recorded.
I'll instruct the college authority.
This is recorded.
Till the filing of the.
Till the filing and moving of an application for interim. If it is rejected, you do whatever.
Yes.
I'm apprehensive because of his submission.
Huh?
I'm apprehensive because of the submission made in that.
It's recorded, Mr.
I'm obliged.
Come back, file an IA.
I'm obliged.
Just file an IA, I'll do the meeting. IA Jigida said disposed. Yes, the next one.
Next, my lord, my learned friend will address it.
May it please your lordship. Here the matter is pertaining to my non-approval in the post of library assistant in the PHB college. An advertisement was issued on 19/5/2022 for filling up the post of library assistant. Page 21. This is URPWD category, RP1. Thereafter, I was selected and the post creation letter that was sent to the DHE authorities by the principal. That your lordship will find at 23, page 23. And at page 27, the post creation letter that was sent on 14/2/2023.
Page 20?
Page 23, 27. This 27, okay. Thereafter, this PWD, this physical verification was held, and I was called on 10/6/2023, which is at page T2 for physical verification. Lordship will find at serial number 27, my name.
62.
62.
You were called on?
On 10/6/2023. The letter is dated 6/6/23 at page 59. The list starts from 60.
Your name is at
62, page 27, CDL 27.
Yes.
Then at page 65, your lordship will find that DHE has informed the principal that this advertisement was issued, but there was a post roster based issue. And that's why the same said post is required to be re-advertised. Thereafter, my candidature that got cancelled. The approval was not granted. Page 65. And thereafter, the next page, your lordship will find the next advertisement was issued for filling up the post of library assistant at page 66.
What happened to this advertisement finally?
But the selection process was taken up, my lord. But
Not completed.
in view of the stay order, my lord, that is done.
Selection was done.
Yes.
Interview and
Yes.
person shortlisted.
My lord,
Is waiting.
perhaps, my lord.
You want to proceed with that? Yes.
And now I'd like to take your lordship to the roster point, which is at page 29 of the college.
Some services.
Your lordship will find 1, 2, 3, 4 of the positions have been filled up already. And as one has expired on 30/6/2021, which has not been stated here, but he expired on 30/6/2021.
Serial number 1.
1.
He expired on?
On 30/6/2021.
30.
3/06/2021. In view of that, this present advertisement was issued, wherein I was selected 19/5/2022.
So that is correct. Roster point 1 is unreserved. And as per the PW Act, that is reserved for PW.
Lordship will see that my affidavit at page 87, my lord.
Page
87. It is the roster point number 7 post. And I have also, my lord, gone through some. The roster point to be maintained. It is published by the Administrative Reforms Department, my lord, 13 per roster, my lord. It is, I find that it is in conformity with that. My lord, I have flag marked, the second flag mark. It is also in the last page, my lord. It was notified in the year 2019, my lord. Perhaps, my lord. I am also learning in this.
we all are learning.
My lord, perhaps it is in conformity with this.
How many cadre posts do you?
My lord, that total cadre is 4, my lord.
4.
My lord, lordship will
And
from the
total
my
cadre
affidavit-
is 4.
Yes, my lord.
You have Sabharwal's decision
My lord.
that once the cadre strength is achieved, the roster loses its significance.
My lord, at present that 4% is not working, my lord.
At that point of time.
No, that point of time also, my lord, I may explain, my lord.
Your lordship.
So where is PWD coming here?
Two and three.
PWD will be 1 only.
My lord.
PW will be 1 because you have more than 4 posts, around 4 posts, so more than 3.
More
So
than
1 will come.
Yes, my lord.
So 1 comes, it will come to RP number 1.
Lord.
Now you come to the, you have page 29?
The repetition, my lord?
No, after that page 29 of the repetition.
Yes, my lord.
And have the, that roster, 13-point roster. Can't read it. You have that roster, 13-point roster.
My lord.
So when the cadre strength is 4, cadre strength is 4.
My lord.
For these are all direct recruitment posts.
My lord, yes, my lord.
Huh? The first initial recruitment would be of OBC.
Lordship.
So this selection list here, or the thing here, if you come page 29.
My lord.
So it is okay. Bhavananda Bora was a OBC.
My lord.
Right? Right?
Right.
So this is placement. After the roster, you have placed for the first time these people. Now you come to the person at 2. In terms of this, first vacancy and second vacancy, right, will be filled up by UR and UR. So your second point here has to be a UR. Third point has also to be a UR.
Lordship.
Fourth one will be SC. Now, which is the post you had initially advertised? Initial advertisement was of 19/5/22.
Let's say.
So on 19/5/22, if you come to the list, he died on 36/21, right?
Yes, 21, my lord.
So that vacancy was there.
No, that vacancy, yes, my lord.
Huh?
That vacancy was there.
That vacancy was there. We'll just find the vacancies. Then you had other 3 posts were filled up. Right?
Right.
In 22, when you issued this advertisement, you only had the post of Bhavananda Bora.
Lordship.
So Bhavananda Bora, a replacement vacancy, it should have been replaced. Roster point should have been replaced because 4 is filled up. Everything done. So once you fill it up, this being a UR post, which was carried forward.
My lord.
Point was carried forward.
My lord.
So point number 1, again, you will have to fill up. Along with that, the PWDs, that was correct.
That exercise was done by the college authority, but it was disapproved by the DHC. And again,
yes, Mr. Das, how have you disapproved?
And again, my lord, that roster at page 87, my lord, it has been approved by the DHC, my lord. Your lordship will find that down below.
80?
Page 87, my lord, my affidavit, my lord. That has been approved, my lord.
Wait, internal page? Ojit Hazarika.
Lordship. Just before the last page.
Just before the last page. Okay.
This is the new roster approved by the DHC, my lord.
Here, the date of death of Bhavananda Bora was not taken.
My lord, that instruction I have taken, my lord. After 2017, my lord, that notification regarding the compassionate appointment in lieu of, my lord, appointment, that full salary, my lord, that has been maintained, my lord, because his services were up to 2023.
That is for the purpose of that. You need
My
not.
lord, only for that purpose that
Because
died column is not filled up.
that will not be. He will not be treated.
Fact
to be
remains
continued.
that fact remains that he died in the year 2021 because of that.
17. But do you mean that if a person dies, till the date he retires, that post will not be filled up?
No, for not that purpose.
Then
Only for the salary purpose.
So we hold that he is no longer there.
My lord.
So his salaries are also not drawn. She is getting compassionate family pension.
Family pension. Equal to the salary.
Equal to the salary, but it's pension.
Pension.
Not salary.
Yes, my lord.
So it's a different held altogether.
My lord.
So here if you see, Now there are more people coming in. Okay, now this is interesting. Come to number 2, Mukut Bhuiya. So on the date where Mukut Bhuiya
was
who
appointed.
is not there in page 29 you prepared. Hoben Bosumatari is not there in the this page 29 is of which year?
29. 2019, I guess. In pursuance of approval accorded by the DHE, communicated by the
Discrepancies
director.
are there, my lord.
No, not discrepancy. See, Mukut Bhuiya, Bhoben Bosumatari were promoted in 2010 and 11. So they are not there in the cadre.
But your
Pankaj
lordship will,
Sharma continued till 24.
but your lordship will see their date of appointment, long back, my lord.
1, 2, 3. 10, 12, 13. So 10, 12, 13.
No,
right?
Mukut Bhuiya was appointed in the year 1992.
Mukut Bhuiya and they were already promoted.
No, my lord, I'm
I'll come to
about
the-
that
I'll
initial
come-
date of appointment.
I'll come to
Yes,
that.
my lord.
Now we have Bhabananda Bora, who was not promoted. Then we have Pankaj Sharma, as on the date you issued that advertisement, 21. Pankaj Sharma, Mrinmoy Nath, and Ajit Bhuiya. Bhabananda Bora died.
Yes, my lord.
Mr. Hazarika, just appreciate this. Bhabananda Bora was there.
My lord.
Pankaj Sharma was there. Mrinmoy Nath, Ajit Bhuiya. 4 posts filled up.
Yes, my lord.
Right?
Right.
Now, when you issue this advertisement in 22, Bhabananda Bora is not there.
No, my lord, in the cadre, my lord, Pankaj Sharma was appointed in the year 2010, my lord.
He was promoted in 24.
Lordship.
So on 21, when you advertise, 22 you
22,
advertise.
22, yes.
Pankaj Sharma, Mrinmoy, and Ajit Bhuiya were in the cadre.
My lord. Ajit Bhuiya, yes, my lord.
Yes,
Ajit Bhuiya.
13 he came.
Yes, my lord.
So there were 3.
3, my lord.
The only vacancy that was utilized was of Bhabananda Bora.
My lord.
Now, if Bhabananda Bora vacancy was utilized,
My lord.
4 posts were there.
My lord.
4 posts filled up. Bhabananda Bora died. That was advertised.
My lord.
What was the mistake? In PWD, you are.
Even if, my lord, if you are go by the, my lord, observation by the medical expert, my lord, he is below the benchmark disability.
That is different thing.
Yes.
That is different thing. You have made a mess of this.
My lord,
because what has happened here is you prepared this sometime in after 2000. When did you file your affidavit?
you filed the affidavit.
December
December
25.
25, my lord.
December 25. So this is prepared before 2013 because Ajit Bhuiya is not shown here. So this was prepared before 2013.
In the second list, Ajit Bhuiya is shown, my lord.
Ajit second list, Ajit Bhuiya is shown.
And the first list also, but it's page
And
19.
for second list, you have brought in, they have brought in Mukut, Bhoben, and Pankaj.
My lord.
Although they have been, Mukut and Bhoben, although they have been promoted and moved out of the cadre.
My lord.
This is prepared much afterwards. When was this prepared? There is no date.
I'll have to after instruction.
No problem. Yes. Mr. Doctor.
Your Lordship, at page 87,
Hmm.
the roster which has been.
No, that is confusing. That is confusing.
That is clear. In
Let us hope, let us take it that you are there for the time being as PW1 and the post was rightly advertised. Now what?
So I should be considered as per roster.
Okay, but what do you say about the medical examination?
There were two medical examinations done in the year 2023. It was
Page?
their affidavit.
My lord, I may point out, my lord, Ajit Bhuia's appointment in the other case, my lord, first one, he was the direct recruitee under the Provincial Election Act. My lord.
Oh, that Ajit Bhuia.
Yes.
Okay.
So Rustar was not patent.
Okay. Yes, page 100 and
Page 93.
which paragraph?
Paragraph 4, second para. Thereafter, the petitioner attended the medical
Okay,
board.
so you say that you had the benchmark.
Benchmark, yes, I had 23%. So
So we
based on
go
that,
by, you want us to go by this 23% and not by the 10%.
10%. Later, it was reduced to 10% on the second re-examination.
Yes.
And
Where is
regarding
the advertisement?
advertisement, the earlier one at page 21.
In 2017, Mr. Hazarika, Mr. Das are the guidelines for this election.
Yes.
9/2/2017, guideline for selection. Guideline for selection. Please come to page 21. This will be 9/2/2017. Persons with physical disability. Tomorrow. Date reports. Anything there with regard to PWD? Yes, Mr. Doctor. Anything more, Mr.
Another thing, the advertisement was issued in the year 2022. Suddenly, after 2 years, 19/5/22, after 2 years in the year 2024, they are coming and saying that there is post roster based issue. Now, due to that, my promotional avenue that has also got affected because I could not apply in the subsequent post as my age limit has crossed in the meantime. So due to the anomalies made by the management, I need not suffer. Your Lordship, there is a judgment in that regard to provide a copy. This is by the Bombay High Court at paras 17 and 18. I'll read. Employment opportunities are a scarce commodity in our country. Therefore, considering the facts narrated herein above, in the context of the petitioner number 3, who have gone through the rigmarole and having been appointed to the post of junior clerk, the petitioner number 3, in our view, should not be made to suffer on account of the irregularities of the petitioner number 1 and 2. In any case, petitioner number 3 had no role in the manner conduct of the selection process. And 18, in the facts and circumstances of the case, we find that the lapse is committed by petitioners number 1 and 2. We could have taken a strict view considering that the participation of the candidates in the selection process was curtailed because of the advertisement having been published in a particularly unknown newspaper, and that too in a dark edition. However, the selected employee cannot be blamed for such tricks played by the management, which needs to be penalized. We are therefore condoning the conduct of the management only because the employee is not at fault by imposing cost of so and so. And thereafter, in the last para, at para 21, the petitioner number 3 herein was considered for the post of junior clerk. So this much, Your Lordship.
Okay. Anything more? Mr. Dotto, now that you have said that we should consider your disability to be 23% as per page 93.
93.
Now, will that bring you within the benchmark disability?
Benchmark is 40
40%.
probably.
So you are much below that. So you won't be able to be considered as a, even if we hold other points in your favor, this will have to be held against you. So you'll
Prior
not
to
be,
that, I was having a permanent disability certificate.
fine, maybe you have not even pleaded in your, you have not even pleaded those things. And this may be a case wherein there is an improvement of your
That may be the
hearing
case.
thing. And this was done by Gauhati Medical College experts.
Yes, yes.
So you have not alleged malafide against them. So on that count, we will dismiss your application. Pass the order at 2 p.m.
Obliged.
5 minutes, I'm coming. Okay.
Lord, I'm
Yes, Mr.
my lord, this matter my lordship has already heard. The issues which my lord arising out that they have produced a rule, my lord. It is named as Assam Survey and Settlement Training Center Rules 1992, my lord. And if we go by the provisions of the rule, my lord, and I have tried to find out the gazette notification of this rule also, but my lord, I could not find out.
This rule, Mr. is being followed, and there are decisions of this court interpreting these rules.
No, my lord, there are decisions, my lord, regarding my
These
lord,
are under the revenue rules.
1886, my lord. No, my lord, even this rule, my lord, that has just a draft had been prepared, my lord. It has not been, my lord, placed.
But this is the rules under which your mandal posts are filled up.
But my lord, in the, because my lord, this is the.
Then you can go and make a challenge to these rules, validity of these rules.
No, my lord, the, my lord, the case when we projected and even in the affidavit also, my lord, they have not said anything regarding this rule also. My lord. Now only off late, my lord, when the case was being heard.
You come to because Mr. Mia,
My lord, my lord.
this training, if these rules are not there, if you argue that these rules are not proper, the whole thing will fall through. Because the training is under these rules. There is no other rule for that training.
My lord, that is admitted. My lord,
You make your submissions, we will say that these rules not having been notified could not have been applied, and accordingly the petitioner has got no ground or no locus to make a challenge to that thing, because that is gone now.
No, that will not, my lord.
It will not help you.
That will not help you, my lord.
Now, if you rely on this rule, you will have to rely on the full rules.
That is correct, my lord. That is because.
And these rules you come to
the
clause, rule or whatever it is.
Reservation criteria.
20. Now, what happens is,
Well,
this is the reverse way of looking at it.
my lord.
You don't look at it from, this is not just a per se ITI training. This is not per se ITI training.
My lord.
In ITI training, ITI is a training. You are trained, you are put to the market. So therein, there is no reservation. Now, you go to the market, you apply. The advertisements are issued, you apply. And then the question of reservation would come. Here, the deputy commissioner is to give a list to the director with regard to the vacancies that would arise in that year. Now, that vacancy list must have the breakup. Basing on that, selection would be done in the district level. Earlier, it was done in the state level, now okay, in the district level. Then the marks and everything are sent to the director here. The director thereafter, with regard to that vacancy, would publish a list. And these people will get absorbed subsequently in that vacancies in that district against the post of lot mondal. Now, Mr. Bhuya, if we don't provide for that reservation there, then the post of lot mondal, the backlog vacancies will remain for like that for 2 years, then de-reservation and filled up by general. So backlog, the reserve community candidates will never have a.
No, my lord, my submission is that, my lord, as the very concept of reservation is for the underprivileged or for my lord, the person concerned who, my lord, deserve the reservation.
This court,
My lord,
in the coordinate bench while passing the earlier orders,
my
that we
lord,
have
my
played,
lord.
these rules were never considered.
No, even these rules were never brought into the knowledge of the, my
So
lord,
this,
both the
that, those
division bench,
orders,
my
as
lord.
far as this is concerned, is it will not be binding on me.
No, my lord, it went to the division bench also.
Maybe, because if it's not considering the rules, in the fact situation of this case, you come to page. That is something you will subsequently test before the division bench. But where is that?
My lordship is.
Some select list was there.
Yes, yes, in my writ petition, my lord.
Where
Yes,
page,
yes, it is in
page
42, my lord.
42.
My lord.
Now you come to page 78. Keep 42 with you and come to 78.
78 of their affidavit.
Affidavit.
Yes, yes, ma'am.
Running page 70. This is for Korimganj, Kachar. This is for Kachar.
Kachar district. Ma'am.
Now you see 20 posts are there, vacancies. It's Annexure C.
Yes, yes, my lord, I got it.
20 posts vacant. Right?
My lord.
Now, 4 posts for SC.
Hmm.
1 is reserved for women.
My lord.
Now you come to page 42. Just keep that and come to 43.
My lord.
You see the distribution there.
No,
So-
no, distribution is there.
No, Mr.
My lord.
There is a thing that 14 have been given to reserve and only 6 have been given to the general committee.
My lord. My lord.
You come there, serial number 15, 16, 17. Schedule caste,
Schedule caste, schedule.
these are men.
Man, my lord.
And 18 is schedule caste woman. So this is satisfied.
No, no, my lord, my case is not that, my lord. My case is not regarding that the reservation criteria has not been followed in accordance with law.
You say reservation cannot be.
Reserve because the rule, my lord, my case is very, when we put the, my lord, petition challenging the, my lord, our rejection was that. In the advertisement, my lord, they have not an iota of mention as regards that it will be followed. Now, my lord, when the petition advances, my lord, then in the affidavit, my lordship may be pleased to find the affidavit also. There is no mention of that, my lord. I have not found that in the paragraph or in the pleading regarding that, my lord, this rule which they are now relying. Now, my lord, as we know that there is a, my lordship is, my lord, note that the Assam Scheduled Caste and Scheduled Tribes Reservation of Vacancies Act is there. My lord, that reservation criteria is followed only for the purpose of recruitment. Now, here is a case, my lord, this is not a recruitment. This is a pre-recruitment condition.
But there is the training, the rules that provide for the training.
Yes, yes.
Also mandates the incorporation of this.
No, my lord, that's why, my lord, the rule which they have followed or not, that is not been clarified in their affidavit also, my lord.
They cannot follow any other rule other than this, what do you call that? RCC training. There is no other rule in this world at
No,
that point of
My
time.
lord, it is there or not, my lord, now as they have relied on by.
You show me that this
My
training
lord.
can be provided under some rules other than this or some executive orders. I'll consider your case.
That, my lord, that input I have not given, my lord, because my impression is that, my lord, as this rule has not been in accordance with the law, so therefore this rule do not have the force
Okay.
of 309, or it is also not made under 1886 regulation also, my lord. So therefore, my lord,
So your submission rules don't
have the force, my lord. To be treated to be a genuine rule that has been notified in Gazette notification. My lord, draft rules are cannot be, my lord.
Fine.
No, my lord. I know, my lord. My lordship is well conversant with this process
I'm
of
conversant with nothing.
my lord. So, my lord, I am very shy to, my lord, make this
No,
submission before my lordship. My lord.
no, never.
My lord.
Please don't make that submission again.
My lord, because my
This
lord,
is if you don't want me to interact, I'll keep quiet.
No, my lord. That will be fatal for me, my lord. Now, my lord, my respectful submission before my lord is that, my lord, as the rules which they have followed, my lord, it has not been. If my lordship, if you go by the provision of the rule, my lord, it is just a, my lord, a draft. Just they have prepared like a draft writ petition we prepared till it is filing, my lord. It is just a draft rule, my lord. Now, how they can, my lord, relied on a rule which is a draft. Now they are saying and coming in the advertisement. It is no mention about the rule. My lord, in the affidavit there is no mention about the rule.
We have already
Now,
stated in the paragraph number 6, in our affidavit. Section 20.
Mr. Bhuya is making his submission. Let him make it.
My lord. So, my lord, therefore, now, my lord, the rule of the game which they have changed subsequently, my lord, by this bringing
Rules.
incorporation of the rules, my lord. Now we are being ousted, though we
Okay.
mark.
So you have raised a plea
My
that
lord.
these rules are not applicable.
Applicable. And secondly, my lord, when the matter has already been adjudicated by my lord, coordinate bench of this honorable
So
court.
tell me, which
My
is
lord.
the rule that would be now applicable,
So, my lord,
wherein that
that
6 months recorder's certificate class course training can be given to you?
No, my lord, there because there is no any such rule they have applied in the earlier occasion also, my lord. Now, whether this rule they have applied or not, it is because if it would have been applied, my lord, then in the advertisement, very advertisement, the mention is there. If just for a moment, my lord, if I beg to draw my lordship's attention to the page 34 of my lord, page 34 of my writ petition, my lord. My lord, kindly peruse the advertisement, my lord. In pursuance of the government letter number dated 22/1/2020, applications are invited from the intending candidates. Now, what this letter contains, my lord, it has not been placed before my lordships also, my lord. Perhaps in this letter, my lord, some mention may be there, because this initiation, this advertisement or the recruitment for the training could have initiated, my lord, pursuant to this letter. So that letter is not a part of the affidavit also, my lord. So therefore, my lord, if we go by the my lord advertisement below, invited from the intending candidates to undergo 6 months recorder certificate class course training at the Assam so and so, Dakhin Gaon, Gauhati 40 for the session 2021. The candidate must be the Indian citizen and a permanent resident of Assam. Format of application, my lord, if we go by a plain reading, my lord, there is no mention as regards the application of any rule, my lord. So therefore, my lord, my respectful submission, my lord, is that in this notification or in the letter, that may be placed on record, my lord. And even then, my lord, my instruction is that earlier also, my lord, when the present rule was not amended at that relevant period of time, or now they have come up with a new notification, my lord, that the graduate degree or the trading.
Now they have a new rule.
New rule, my lord, new rule. So, my lord, before the earlier rule, what was the rule exactly they are following in the earlier advertisement or in the earlier recruitment? If the reservation criteria they did follow, my lord, then we can say, my lord,
This
that
is an
yes,
advertisement of?
Advertisement of 2020, my lord, 27/1/2020, my lord. So therefore, my lord, my respectful, because my lord, if we oust from this selection, my lord, as they have already ousted us, then my lord, in future there is no scope
This
for our
1991 selection.
My lord.
This 1991 recorders class course.
My lord.
Selection.
My lord.
2006-7.
My lord.
there was a volume matter here.
No, yeah, my lord, it
My
is,
Lord Justice Ranjan Gogoi's
my
final
lord.
order. It was
Just,
passed
just,
on this.
just, my lord, we join thereafter, my lord.
Ah.
That's why we may not be so,
May not be.
my lord, my lord.
These rules were the rules under which after a long many years, the recorders class course training examination was held in the state.
My lord.
After maybe 10, 12 years in between, there were litigations here. So in that litigation, it was these rules that were followed.
My lord.
And fortunately, unfortunately, I was that side.
My lord. My lord.
The side for the director. And that examination was held under these rules.
My lord.
So this validity of these rules, if you go back and look at the history, they have made it in a bit clumsy manner. These rules are pre-independent rules.
This rule, my lord.
These rules are pre-independent rules. It is there from 1895.
But my lord, which we are holding
And
is in
these rules
my lord.
that they have said that 91, this was an error. It should be because they have made it effective from 88.
My lord.
There is a rule in operation from 1895, retained in 1935. And the whole entire mechanism of recruitment of this, it's not only that.
My lord.
You have not only that course, you have different courses. You have courses for chairman, chainman. You have courses for ACS, APS, IPS, ACS, forest. They all come and here and do this training.
Well,
so this is not an institution that you can just say it's there, just there. No, it's an institution entranced by the British for revenue.
No, my lord.
Lordship, my lord, that ACS and alia, they are also.
Where is that 2023 rules?
Lordship. Oh, my lord, on my lord, the 14th, 2026, my lord, one advertisement was published. Regarding my lord, one-time measure, those who are completed the 6 years or 6 months, my lord, RCC training, lordships. As because my lord, new rule come. After the new rule, my lord, it is already been, my lord, affected from 1/4/2026. So from the new rule, my lord, the training will be, my lord, started after the my appointment, lordships, due selection, lordships.
No, what Mr. Bhuyan is saying, we can't just brush it aside. There is some substance.
Lordship. And when my lord, now, my lord, that no new, my lord, that RCC training is be held. After that, the new rule is.
The rules corresponding to these rules, a relevant part of Assam so-and-so, the rules of this rule so-and-so, relevant part of Assam Survey Settlement Training Center Rules 1992, which are in force immediately before commencement of these rules, shall not be applicable in case of the Assam Land Record Subordinate Service.
Mal.
So this rule.
It has the mention of the earlier one.
This rule is a recognized rule. You can call it an administrative executive instruction, but that is the one which is holding the field. Even if you say that this does not have the force of a rule, it will be an executive instruction, and there being a gap, this will come in.
No, my lord, without the rule of the law or without any procedure prescribed, my lord, it is always difficult to, my lord, arrange certain things, my lord.
I'll try to do something so that you can get it further clarified in the division bench, so that for future we have a law.
Now, my lord, while my lordship is going to consider, my lord, then the division bench and the single judge's order, which is also there.
I'll consider everything.
My lord,
where is the division bench order?
My lord, exactly similarly situated persons, my lord. Now it will be a discrete, because this present batch of petitioners.
If required, I'll refer. If the
no, my lord,
what comes, I'll refer it to.
No, my lord, what my respectful submission is that, my lord, the petitioners who were given the relief by this honorable court, my lord, are exactly similarly situated with the present petitioners.
Just show me that.
No, that order, my lord, I have.
Where is the division bench order?
My lord, the division bench.
I have Dipankar Majumdar
and another, my lord, and yes, my lord.
Dipankar Majumdar and another. That 5937, there are 3 orders of 5937.
No, no, my lord, the division bench order at present, my lord, I am not holding, but I can provide, my lord. Dipankar Majumdar and Rajat Goswami's case had been dealt with by the, my lord, exactly coordinate bench.
I have seen that, but the coordinate bench has not factored in on the very rule under which they were taken for training. Or rule, we call it a rule, executive instruction.
But my lord, it was, my lord, I have to submit fairly, my lord, because that rule on that proceeding, my lord, was not brought on the notice
What
of
is
this.
the writ appeal number?
Lord, let me give it back.
Writ appeal 68/2022.
My lord.
31/3/2022.
Now, my lord, the difficulty is that, my lord, as per the new advertisement, my lord, we are not graduates. So now, my lord, if we are ousted from this process, my lord, then in future also we will not be able to apply again. So, my lord, similarly as a one-time measure, my lord, can be, my lord, my lordship.
So even if we allow you
My lord,
as a one-time measure,
my lord.
you will have to again go undergo this training for Mondal, because now Mondal you will have to have the graduate qualification.
No, that is correct, my lord. That is correct. So, my lord, if we take an acquire a qualification, my lord, this qualification may help in future also, my lord.
No, for Mondal post, you are not going to be recruited because there the qualification is now graduate.
My lord. No, my lord, in the meantime, I have, my lord, they have both have cleared the graduation degree, my lord. That's the issue, my lord.
If they have the qualification, my lord, if he is my lord a graduate.
You file an application now, the next round of selection,
He can
clear that, you are admitted for direct for the job of Mondal, and then they will train you.
training, lordship.
My lordship knows it is, my lord, every chance of getting rejected is more, my lord, than the selection.
Rejection, mister, that is a chance, because there will be lakhs.
That's the problem, my lord.
And the post is 160. Now it is again reduced because it will be to the extent of the vacancies in the post of Lot Mondal. Earlier it was 160 training. So people, I personally know people, the qualifying in the written examination was 5,000, 6,000. That was the level. Just a second. No? This is distinguishable.
No, yes, my lord. My lord, the paragraph which, my lord, may I be permitted to read one paragraph, my lord? I am reading in page 3, my lord, the last paragraph of page 3 of this single judge's order, my lord. At the very outset, it deserves to be mentioned herein that the advertisement dated was issued inviting application from the intending candidates only for undergoing the RCCC training program and not for filling up any vacant post. There is also no mention in the advertisement notice dated 21/1/2020 regarding reservation of seats for any candidate. Therefore, it is apparent that subsequently, by applying the reservation criteria, the authorities have tinkered with the inter se merit position of the candidate, which had resulted in denial of opportunity to participate in the training program to a number of general category candidates, including the writ petitioners, who had scored higher marks than some of those candidates who had been admitted in the training program. While examining the said aspect of the matter, the division bench of this court had made the following observation in the order dated so and so. Our prima facie opinion on this is that it is not a formal selection where the reserve posts have to be filled up by the member belonging to the community for which the seats are reserved, and in the case there are no candidates available, the seats will be carried forward for the next year. For the training, the same principle cannot be adopted as firstly, it is not a process of selection to a post, but it is a training where 2 seats will remain unfilled throughout the period of training if the petitioner are not sent, and secondly, the training is only for a period of 6 months. My lord, my respectful submission, my lord, is that whence a notice with a conscious decision, my lord, they have notified or floated. Lord, wherein there is no provision.
What has happened is in Karimganj,
My lord,
which is pertaining to that case,
my lord,
2 posts were kept vacant
vacant, my lord. That is correct.
because there was no corresponding candidate from the reserve community.
My lord.
Then this court said that post will remain vacant. Better he is having marks, give it to him.
No, that is the direction, my lord.
But
the
here,
my lord.
in this case, it's not the case. There is no post vacant.
No, that is correct, my lord. But
Now the application of the question of reservation,
my lord.
that the division bench, nor the single judge
my lord.
followed, and there is no prescription. It is on the facts of that case that this conclusion was arrived. And by the way, training in the context that there were 2 vacancies available, that observation was
But
made.
my lord,
We will deal with it.
my lord, my very limited understanding is that, my lord, the ratio of the law, my lord, which has been fixed
This
by
is not a ratio given. If the ratio would have been if the rules were taken into consideration. There is no ratio. This is a finding given in the facts of that case.
my lord.
We will limit it to that. So, second up, there is there is one order to be passed.
My lord.
You be there, but if I require you, I'll ask you. Ask your junior to be here.
My
If I require you, I'll just call you. I'm not. While dictating, I may place something. Because we always keep on changing.
Let's hope for a positive change, my lord. For me, my lord.
Can't deny
My
that. Can't say no.
My lord.
Say no. There is no rigidity here.
My lord.
Until and unless.
No, my lord, after all, we are governed by the rule of
Until and unless the order is finally signed.
My lord.
And they upload it. I have
Yes, sir.
moved up. I have moved up. Hot process, can't help it. Promoter keep on ask. 9-2. Oh, 9-2 TTD. 9-2 deacon. He is free. He is there.
We are trying to contact the standing council of GMC, my lord. We are not able to communicate, my lord. So, I've informed them, my lord.
Commercial license is given,
Commercial license is given, the building is a residential building.
but you gave it, you made a, you have inspected that then when you gave it.
But I will show it, my lord. I've got the instruction letter. This is a residential building.
I know that, but why did you give it, give a plan, give an approval when you had granted that approval?
But they may be effectual, they might be wrong, my lord.
So without giving her notice, how can you now?
That notice should have been, but here the person who is aggrieved is the company, who is respondent. He had not come before the, it is the
Fine.
owner of the building has come.
The owner, there is a lease agreement, it has been given by
Yes,
the owner.
A dealing order has been issued to the owner.
Owner, and the owner is Joya Monto.
Yes, my lord. Lordship will turn to my first page, my lord. First we'll see there is a complaint. Thereafter the last page, my lord. Residents of carrying the complaint.
But this is a very genuine thing, Mr.
My lord, Lordship turn to the last page.
You operate something in a residential area and then you don't allow the people to sleep there. Why should we permit you to continue?
My lord,
We can visualize what is the activity going on there. Because that Blinkit, they have stored things there.
24/7
So
they
night,
run.
2 o'clock also they may come, people may come with the vehicle in a residential area, get in, shouting.
my lords,
Lordship, can't you see the last page?
my instructions are
that
maximum efforts have been made to
serial number
minimize
3.
such noise and disturbance.
It's not maximum. There should be no noise, no disturbance to any person.
Yes, that is our endeavor, your lordship. That there is no disturbance.
Serial number 3, last page, my lord. Use of the building. Building is for permission.
I know that for residential, but why
But
did you
see
give
the
him?
clear violation of.
And why a notice was not given to her?
No, that's a
After the amendment, that notice is mandatory.
Notice there is a violation. Notice should have been there.
So we will make it operation successful, patient dead.
They cannot run it, my lord, because it's a clear violation of appendix.
Set aside this, we'll set aside this, give you liberty to proceed in accordance with law.
And in the meantime, let them at least remove the lock because they are perishable.
We are asking them to deseal the property,
Very well.
but they will now proceed in accordance with law.
Very well. After giving us an
At the same-
opportunity.
Lords, at the same time, my lord, this building is a residential area. This is when a residential area is used as a commercial area. It's a clear violation of appendix 3. This is
I know that,
non-compatible.
but you yourself gave that
My lord,
license.
that is there, my lord.
So that license is not cancelled till now.
In fact, it was renewed on 8/5,
License-
2026.
Trade license,
2027, the license stands.
trade license is a different thing. My lord. Trade license online, everybody can take it out, my lord. It's
No,
all.
you have made, you might
There is
have
a-
made
there is
an
a-
inspection for that.
There is an inspection. I have seen it, my lord.
Then
But this is a residential building. This is a clear violation of appendix 3. The non-compoundable offense.
And
Use
in
of
fact,
the
if your lordship has page number 55,
Hmm.
they also, the deputy commissioner of the dispute zone, he acknowledges that they are also receiving property tax at the commercial rates, your lordship. When that is being done. Because in
That can be-
Gauhati, most areas fall within the
they did not think this much when they gave you this. You went there. Bechara, they were having many files. They just cleared.
Now you
But
can take
now
out.
when a Frankenstein has been created there, they have woken up.
Now you can take out the trade license at any time.
When can you file your affidavit?
Shall give you at least 1 week time, my lord.
Heard Mr. KP Pathak, Learned Counsel for the petitioner. Also heard Mr. S. Bora, Learned Counsel appearing for the Learned Standing Counsel GMC. Issue notice returnable. How many?
I am appearing for 1 to
No. How much time do you want?
1 week time.
Returnable on. Sorry. On 12. On 15/6/2026. So, Mr. S. Bora, Learned Standing Counsel, GMC accepts notice on behalf of respondent number 1, 2, 3, 4, 5, 6. 6. Also, no formal notice, huh? No. Petitioner to take
7 is a private respondent, my lord.
a private take steps by Dusty Moot for service of notice upon the respondent number 7. True, they have an office here.
They have authorized person here, your lordship. because they are operating out of these stores only, not a.
So for 7, if we don't give you notice, how will this notice go?
My lords, I'll serve it on the registered address at in Gurgaon, my lord. By registered post.
By registered post, it will not come back before 4 weeks.
My lords, then my lords may then allow me to serve it to them through their authorized personnel in Gauhati.
Please, Pusam, as prayed for by Mr. K.P. Pathak, notice upon respondent, pro forma respondent number 7 is permitted to be served through the authorized person stationed
In
at
Gauhati.
Gauhati.
My lords.
The authorized person of the company stationed at Gauhati. So, the petitioner in the present petition has assigned a notice dated
3/6/2026
3/6/2026 issued to the issued by the enforcement official, Gauhati Municipal Corporation, towards sealing the premises of the petitioner, wherein were leased out to the respondent number 7 company with immediate effect, that is with effect from 3/6/2026. Also, the petitioner, while a lease deed dated 7/6/2025 had leased out her premises to the pro forma respondent number 7 for setting up of its establishment therein. Also, the materials brought on record in the writ petition reveal that a trade license was taken out by the respondent number 7 for operating its business in the premises leased out to it by the petitioner herein. Also, the said premises is also found to have been assessed as a commercial property. Assessed for property tax as per page 55.
Yeah, property tax.
As proper for property tax as a commercial property. Also, the property tax bills brought on record also reveal that the petitioner has been continuously paying the tax, property tax, by construing the premises in question to be a commercial property. Also, basing on a complaint raised by the neighbors of the said premises, the respondent GMC had, while communication dated 21/2020, required the petitioner to furnish all requisite documents pertaining to the premises in question. Also, it is contended that the petitioner had furnished all such documents. The petitioner has further brought on record the trade extension of the trade license granted to the respondent number 7 for operating its business in the said premises, which is now valid till 31/3/2027. So, it is in the above background that the enforcement official, basing on the complaints raised by the neighbors of the area, had issued the said notice dated 3/6/2026 towards sealing the premises in question. It is submitted by the learned counsel for the petitioner that the premises has since been sealed and it is presently under lock and key it's presently locked by the GMC officials. The learned counsel for the petitioner further submits that prior to issuance of the prior to sealing of the property of the petitioner, said premises of the petitioner, the respondents, which is the provision?
The power flows from section 337, which your lordship will find at page number 41, and section 404, which your lordship will find at 40. If your lordship has 337 and 404, if your lordship has 404, subsection 3 at the bottom of the page, whoever contravenes any provisions of the section, subsections, or clauses of this act, or any bylaws framed under this act, and if such person has been asked to do certain act or to refrain from doing certain act, fails to comply with any requisition lawfully made upon him under any of the said sections, subsections, or clauses shall be deemed to have committed an offence punishable under the appropriate section of the IPC.
Commits that.
The commissioner or an
Commits
officer
that.
may
The current counsel for the petitioner further
perform the act of closure.
the provisions of section 404 bracketed subsection 3 of section 404 of the Gauhati Municipal Corporation Act 2021. No, this is original act is 1969.
1970.
Amended. Has not been complied with prior to the sealing of the property of the petition. Mr. S. Bora on instructions have submitted that the property in question, the property is present, the premises is presently situated in a building which is denoted as in the master plan as a residential building. Accordingly, he submits that a commercial activity therein was not permissible. Also, Mr. Bora, however, submits that a notice requisite in the matter is not found to have been issued to the petitioner prior to issuance, prior to sealing of her property on 3/6/2026. However, he submits that he would receive further instructions in the matter and file an affidavit on behalf of the GMC authorities on or before 12/11/6/2026. Will do.
No, maybe there are some materials of the respondent of 4. We can open it and they can take back all the goods.
That we will finally pass that on. I'm giving this opportunity only to make some alternative arrangements. But legally, we can't pass that order today. We'll pass it after you give you this. In the meantime, ask 7 to do what is required to be done.
My lords.
GMC authorities. He submits that the before 11. Also, considering the grievance raised in the petition, in the present petition, and also appreciating the contention raised by the learned counsel for the petitioner, that the sealing of the premises was so done without complying with the provisions of section 404 of the subsection 3 of section 404 of the Gauhati Municipal Act 1969. This court directs the GMC authorities that till the returnable date, the property will be desealed and permitted to be operated by the respondent number 7 as before. However, it is directed that the petitioner and the pro forma respondent number 7 shall operate, the petitioner shall ensure that the respondent number 7 operates its business in the premises concerned without causing any disturbance to any person in the vicinity of the said premises. The GMC authorities shall monitor the said aspect of the matter and shall monitor the said aspect. Raised it to list this matter on 15/6/20.
My learned friend can inform his clients, then perhaps the receiving can be.
He will do it now only.
My lords.
The present order be communicated to the GMC authorities. Mr. S. Bora is requested to communicate the present order to the GMC authorities for immediate compliance. We'll get it now.
Fixing on 15th.
15th. But this thing, monitor, there is something, just put it down serially in the, and the court will take care of the matter.
Deeply obliged.
And Mr. Pathak, ask your client, you have got your order. Now that thing should be.
We'll take care.
This is too much.
It's a clear violation of appendix 3 and this is a
Not violation, Mr. Bora. If you open eyes, you give this permission. Huh? And you, the other people are not paying you tax. Other people are not paying you tax.
Use of the particular building, my lord. If it's a commercial, you cannot use it.
You don't know. Your associate planner does not know this. Your planner does not know this, that this building is a residential building. Still you take only money you want. Only money you want.
At that time, my lord, they are thinking of only revenue.
Once you do that, this is what is the tsunami that is going to come.
Yes, my lord.
Deeply.
Next time it comes before me, you are in trouble.
My lord, I will ensure that there is no disturbance.
Next time it comes before me, you are in trouble. Yeah. What number? Okay. Yeah. Sir Sahiballah, what are you waiting for? Item
25.
Oh, the debarment notice, product firm.
Yes. Actually, it provide also, my lord.
Oh, you say there is no notice.
My lord, department, my lord.
But the product debarment
without
notice is
cancelling
there.
the contract, without cancelling the contract.
There is a debarment notice of the product. But whether the firm has been given a notice to them.
Blacklisted also, and moreover, no cancellation of the contract.
Gorkha and all those things you will.
Or High Court judgment be there.
Same.
Only.
Let Mr. M. Sahiballah be here. I have 2 orders to pass. Just kept it in the second half. If possible, we'll take it up today only. He'll call you. You can just have.
I'm in the court, my lord.
You can relax. Why so solemn look? Huh? Seem to be very angry today.
No, not yet.
No, not angry. Okay, then fine. A report is here. Yes.
Yes.
What is your take?
Lordship, yes, as per my report, Lordship,
Will not go beyond the report. See,
yes,
you also honorary,
yes,
he also honorary. Now we know that all honorary services have to be regularized. Any honorary teacher coming before me, I'll pass order for regularization, taking this. I'll pass orders now. Huh? Now you are honorary, he is honorary. Both have been regularized on the same day. Now how do you determine the seniority? Seniority can be determined only by the date on which you were born.
yes.
He is found to be born, unfortunately, earlier. So he is given. Now what can?
No, Lordship, Lordship, according to date of birth,
You are senior.
Yes.
Then you will get it.
Yes.
This appointment is in question. Whether there is any.
Your also appointment is in question.
Lordship, the high school was provincial election in the year 1982. Subsequently, the school has been upgraded to higher secondary school with the staff pattern. Where I was there, he was not there at that time. The staff pattern was set.
Subsequently, the services of both were regularized and they have been receiving graduate scale of pay with effect from 27/3/1996. Who is Samsul Haq Pradhani?
His service was never regularized with the from 1997. There is no order to that effect. And there is no appointment order also. He has annexed one appointment order.
I got it wrong. The inspector of school submitted. Abdul Mannan, PGT. Abdul Mannan is the petitioner.
Yes.
On 30/12/95. 27/1980. When was the school provincialized? When was the school provincialized? The original school?
School provincial 1982. High school is provincialized.
And the higher secondary section?
Higher secondary, that is 1996, it was formally announced. And prior to that, Lordship, the higher secondary was running. And 1997, Lordship, 96, the school has been upgraded formally with the staff pattern.
When was the higher secondary section started?
1992. 1992. Well, at that time, on Zobeda was the teacher. He was not there.
You were all PGT in the higher secondary section.
Yes, higher secondary school.
So not, literally, it's not a honorary appointment. It's a appointment in a non-provincialized school.
Yes.
Yes.
So my service cannot be treated as an honorary sir. His service is honorary sir.
No, Lordship, no, that is I am disputing of this because
His appointment order is at page 19.
Okay. Where is the appointment order?
yes,
Page 19.
And where is yours?
Lordship, I have on the last day, I have submitted 4 papers. That is there.
But in one of this paper, Samsul Pradhani, okay.
Yes.
He is not there.
He is not nowhere in any of the document, Lordship, I have submitted. He is illegally receiving salary from received salary from 1997. 90.
Lordship, may I submit? Yes, Lordship, only come to page 19.
19.
Yes. In pursuance to DC letter number so and so, dated so and so, Mr. Zobeda Khatun, subject teacher in English, had left for joining in the Alamganj SS school. The managing committee of this institution had appointed Abdul Manna, that is petitioner, in English in place of Zobeda Khatun, dated White Resolution number 3rd, dated 10/12/1995, which had communicated to the DSE for favor of kind approval. So Abdul Mannan is hereby appointed as subject teacher in English at the scale of science. Lordship, kindly see the resolution and that appointment I have.
Oh, these things you should have brought.
Yes, Lordship, later on that there is a clarification, Lordship, regarding his appointment. I have to go. Okay. Lordship, 6th August 1999.
So you came in 95 only. 96.
No, 95. 95. Prior to extension of
96.
the post.
25/3/1996. The
No.
appointment order is 25/3/96.
Yes.
So you are there from 1996, okay?
Yes.
We'll take it that you may have been appointed, but he was appointed earlier.
No, Lordship. No, provincialization, Lordship's service, Lordship, on the same date. As per the report of the director.
And date of birth, who is?
Lordship, I am senior.
Your senior.
Yes.
Where is your date of birth?
Yes, Lordship.
Page 23, Lordship.
Okay. For the time being, we will follow the principle followed by the director. But Mr. A.Z. Zamet, Learned Counsel for the petitioner, also had Mr. M. Khan, Learned Counsel, appearing for the respondent number
7.
Also heard Ms. Tarangli, Learned Standing Counsel, Secondary Education, and Ms. M. Khan, Learned Counsel, appearing for the respondent number 7 on KVN. Also, the petitioner in the present petition has presented a challenge to an order dated 27/2/20 issued by the Director of Secondary Education, allowing the respondent number 7 herein to hold the charge of the post of principal of Sapar Raumari Higher Secondary School until further orders with effect from 1/3/2026. This court on 22/4/2026, while considering the present writ petition and on noticing the submissions made by the learned counsel for the parties, had required the learned counsel for the parties to submit the requisite document, submit their respective documents to the Learned Standing Council Secondary Education. The Learned Standing Council Secondary Education Department was directed to place the said documents as submitted by the petitioner and respondent number 7, herein before the Director of Secondary Education Assam. Also, the Director of Secondary Education Assam was directed to examine the said document and place before this court a finding with regard to the service status of the petitioner as well 7 and service status of the respondent petitioner and the respondent numbers. Also, the Director Secondary Education Assam, on examination of the documents submitted by the petitioner as well as the respondent number 7, has submitted a report dated 29/4/2026 for this court. On a perusal of the said report, this court finds that petitioner and the respondent number 7 were appointed initially in the higher secondary. When was the higher secondary school provincialized?
1996.
1990?
High school provincialized
No, no, no.
1982.
Higher secondary school.
Higher secondary upgraded 1996.
Finds that both the petitioner as well as the respondent number 7 were appointed initially in the higher secondary section of
Sapar Raumari SSC School.
Sapar
Sapar Raumari Madrasa SSC.
What is the name of the school? Raumari High Secondary School, when it was in its venture stage. Also, the said high secondary school was provincialized in the year 1996. Also, the petitioner herein was found to have been so engaged as a postgraduate teacher in English, in the subject of English, on 30/12/1995, while the respondent number 7 was found to be so engaged as a subject teacher in
English.
Both in English, with effect from 27/1993 by the managing committee of the said school. Also, the services of both the petitioner and the respondent number 7 is found to have been regularized, provincialized, with effect from 27/3/1996 and with effect from the said date. The petitioner as well, you are getting graduate skill,
Yes.
not postgraduate skill.
Perhaps was.
Yes, mister, you are getting graduate skill or postgraduate skill.
The PGPs are postgraduate skill.
No, the director says
Here is given a graduate skill.
graduate skill.
Public postgraduate, sir.
But here they say it's graduate skill. Okay. Where is your provincialization order?
Lordship, I have given that copy, Lordship, in the first page. Post was sanctioned on 12 March 1996. First page.
Given the graduate / postgraduate skill with effect from 27/3/1996. 27/3/1990. Also, the director, by considering the initial engagement of the petition and the initial engagement of the petitioner as well as the respondent number 7 in the said school, has concluded that the initial appointment of the petitioner being earlier in time than that of the respondent number 7, the petitioner, the appointment of the respondent number 7 in the school being earlier in point of time than that of the petitioner hearing, the respondent number 7 was held to be senior to the petitioner, and accordingly, by the order dated 27/2/2026, he was permitted to hold the charge of the post of principal of the said school. Also, on a consideration of the contentions of the report submitted by the Director, Secondary Education, Assam, dated 29/4/2026, report dated 29/4/2026, submitted by the Director of Secondary Education, Assam. This court is of the considered view that the contentions raised therein and the determination made with regard to the seniority of the respondent number 7 for the purpose of identifying the teacher of the school to hold the charge of the post of principal falling vacant therein is not erroneous. Accordingly, the prayer of the petitioner for passing of an interim direction in the present petition stands rejected. Upward issue notice. Upward issue notice. Returnable 4 weeks. So, however, it is provided that such engagement of such appointment of the petitioner of the respondent number 7 as the principal in charge of the school shall be subject to the outcome of the present. The present petition be not treated as a matter and or tied up matter with this court any further.
Notice issued.
Notice issued.
May Lordship permits me that one clarification regarding the two rooster bill. That rooster at page 29 annexed by the writ petitioner millet, that was containing the existing employees of in the cadre millet.
But that your register is all the employees who had come into.
No, my lord, I am coming to that. Lordship will see page 29 first.
Yes, yes, got it. Yes.
Accordingly, that on the post-based roster, my lord, that post was advertised as the RP1, my lord, PW unreserved. Selection was made. The name of the petitioner was forwarded to the DHC, my lord. Then by a letter dated 28/5, it was regretted and sent it back, saying that you incorporate all the employees who has already promoted from the cadre and maintain the rotational basis, the roster, my lord. Accordingly, the new roster at page 87 was prepared, my lord. That's why the additional two names came in. And according to that rotational basis, my lord, this post came under roster point 7, my lord. Accordingly, it was unreserved and he did not
challenge that.
Challenge.
But Mr. S. Dr. Learned Counsel 42. Also heard Mr. S. Das, Learned Standing Counsel, Higher Education Department, appearing for the respondent number 1 and 2. Itu hole mo yat diri mo sen. But Mr. S. Dr. for the petition. Also heard Mr. S. Das, Standing Council, Higher Education, hearing 41 and 2. Also heard Mr. P. Hazurika, Learned Council, hearing for respondents number 3 and 4. The petitioner in the present writ petition has assailed a communication dated 28/5/2024 issued by the Director of Secondary Education, Higher Education, regretting the proposal submitted for appointment of the petitioner against the post of library assistant in Yagbir. This is the full name.
Please, in my petition, my lord, page 86.
No. The school name.
It is Yagbir Hemborua College.
Hemborua Beleg, huh? College. Also, the petitioner has further presented a challenge to advertisement issued on 21/6/2020 for the post of library assistant, against which he was so selected earlier by the college authorities. The petitioner has also questioned the issuance of the second advertisement dated 21/6/2020 by now placing the post of library assistant against roster point number 7 bracketed UR. The facts in brief requisite for adjudication of the present petition is noticed as also, on 19/5/2022, an advertisement was issued by the principal of Yagbir Hemborua College, bracket hereinafter referred to as college, inviting applications from eligible candidates for filling up of a post of a library assistant available in the college. The said post was so advertised against a roster point number 1 for UR and was reserved for candidates with PWD candidates. The petitioner, being a candidate having hearing impairment, submitted his application in pursuance to the said advertisement dated 19/5/2022 along with all requisite documents. It is projected that thereafter the petitioner had appeared in the selection process conducted by the college authorities, and it is projected that it is further projected that he was selected in the said selection process against the post of library assistant. Also, the selection of the petitioner by the selection committee having been approved by the governing body of the college, a proposal was put up before the Director of Secondary Education, Assam, for grant of approval towards appointing the petitioner as library assistant in the college. Also, the proposal being received, the Office of the Director of Higher Education, Assam, and provide communication dated 4/2/2023 required the principal of the college to furnish post-sanctioning order post-sanctioning letter post-creation letter in respect of the post of library assistant against which the petitioner was so selected. The said documents were forwarded by the college authorities to the Director of Secondary Education. Also, the college authorities had also forwarded to the director a rooster register against the post of maintained in the college with regard to grade 3 posts. Also, the director of secondary education Assam, higher education Assam, on a perusal of the materials placed before it along with the proposal as forwarded in respect of appoint selection of the petition against the post of library assistant, proceeded wide communication dated 28/5/2020 to inform the principal of the college that the proposal submitted for appointment against the post of library assistant was regretted. It was projected that the post in question was required to be so advertised. But it was further highlighted that the post was so advertised without rotating the rooster point in terms of the 13-point rooster as incorporated in the provisions. 13-point rooster as contained in the appendix to Annexure 2 of the office memorandum dated 2/7/1997. Also, the college authorities thereafter, after preparing a fresh rooster with regard to the grade 3 post available in, with regard to the sanction strength of the grade 3 posts in the college, proceeded to issue an advertisement dated 21/6/2024 for the post of library assistant, and therein had advertised the said post against rooster point number 7, bracketed UR. Also, the petitioner being aggrieved has instituted the present writ. Mr. S. Dr. Learned Counsel for the petitioner, by reiterating the facts noticed herein, has submitted that the college authorities while issuing the advertisement dated 19/5/2020 had correctly determined the rooster point against which the said post was so required to be filled up. It is submitted that the incumbent who was in the rooster register placed against rooster point number 1 on the date when the said advertisement was no longer in service, having passed on 30/6/2021. It is projected by Mr. Dr. that the rooster point number 1 is reserved for unreserved. You are an unreserved candidate and is further reserved in terms of the provisions holding the field for a PWD candidate. Accordingly, he submits that on the date of the selection, there having been already recruitments made against 4 posts, and all the 4 posts being filled up by applying the theory of replacement. By applying the replacement theory, the college authorities had not committed any error in advertising the post against a post of library assistant against RP roster point number 1 bracketed UR. It is submitted that the selection of the petitioner was conducted in accordance with the procedure laid down in the matter, and he admittedly being a PW candidate with a PWD candidate, a candidate belonging to the PWD category, the recommendation made in this connection by the governing body of the college for his appointment was required to be accepted by the Director Higher Education. Mr. Dr. further submits that even if there was any error in assigning the booster point to the for the recruitment in question, the petitioner not being at fault with regard to the same, the petitioner ought not to have been penalized by depriving him of his due appointment in pursuance to his selection for the post in question. Mr. Dr. has accordingly submitted that the communications dated 28/5/20 as well as the advertisement dated 21/1/2024 by which a fresh process of recruitment against the post of library assistant with a change in the point was so initiated would mandate an interference. For contra, Mr. S. Das Learned, Standing Counsel, Higher Education Department, has submitted that the petitioner being only a candidate selected candidate, no right has accrued to him for being appointed against the post in question. It is submitted that the director is mandated to examine the selection process along with the attending factors before granting approval to the recommendations made by the governing bodies with regard to recruitment against vacant posts figuring in the provincialized colleges in the state. It is submitted that as per the procedure mandated, the petitioner was required to appear before the medical board constituted at the Gauhati Medical College to ascertain the extent of the disability suffered by him. It is submitted that such procedure is also followed in case of all selected candidates for various posts in provincialized colleges of the state. Mr. Das submit that the petitioner, on being examined by the Medical Board of Gauhati Medical College on 10/6/2023, it was found that the disability suffered by the petitioner was to the extent of only 23%, and accordingly, he cannot be deemed to be a person with benchmark disability, and on this count alone, the petitioner would not be eligible to be so recruited against a post which was so advertised by reserving the same for PWD candidates. Mr. P. Hazarika, Learned Counsel for the petitioner, submits that the initial roster that was prepared by the respondent college, respondent number 3 and 4, by the respondent college, by the authorities of the respondent college, was so prepared by only considering the persons in
Existing
position,
indicator.
in position as on the date of preparation of the same. The persons who had earlier held the post, a grade 3 post in the college, were and subsequently promoted to the next higher grades, were not incorporated in the said roster. Considering the said roster so prepared, it being evident, it being determined that the post of library assistant would now be required to be advertised against roster point number 1, bracketed UR, by reserving the same for a PWD candidate, PWD category, comma, the college authorities had proceeded to issue the advertisement dated 19/5/2020. Mr. Hazarika admits that the petitioner was selected by the selections committee as constituted for the post of library assistant, and his such selection was also approved by the governing body of the college. Mr. Hazarika, however, submits that when the matter was forwarded, placed before the director, Higher Education Assam, for approval, the director had required the college authorities to furnish all requisite documents in the matter. It is submitted that thereafter the Director of Higher Education, on a consideration of the documents coming on record, had come to a conclusion that the determination of the roster point against which the advertisement for the post of library assistant was so issued was clearly erroneous. Accordingly, via a communication dated 28/5/2024, the proposal sent for approval, for grant of approval for appointing the petitioner against the post of library assistant as advertised by the advertisement dated so and so 19/5/2022 came to be regretted. Mr. Hazarika submits that in view of the said developments taking place, the petitioner taking place, no appointment order came to be issued to the petitioner in the matter. Mr. Hazarika has submitted that the selection process initiated in pursuance to the advertisement dated 21/6/2024, although taken to its, although completed. However, in view of the interim directions passed by this court-wide order dated 17/7/2020, the results thereof have not been declared by the college authorities, and presently the same is kept in seal cover. Also, Mr. Hazarika, by reiterating the submissions made by the Learned Standing Council, the Higher Education Department, that the petitioner being not found to be a person to be having benchmark disability, his appointment against a post reserved for a PWD candidate not mandate to be so effective. Mr. Hazarika further submits that the petitioner, on being examined by the Extended District Standing Medical Board, Honitpur, his disability was detected to be 10%. Accordingly, Mr. Hazarika submits that it being the mandate of law that for being appointed against a PWD category, as a against PWD category post, a person must have benchmark disability of not less than 40%. Accordingly, it is submitted that the petitioner hearing not having the benchmark disability from his case in pursuance to the recruitment exercise initiated by the advertisement dated 19/5/2022, not mandate to be taken to a logical conclusion. So, in the above premise, the claims made not mandate. I have considered I have heard the learned for the party. The petitioner admittedly in pursuance to an advertisement issued on 19/5/2022 for the post of for recruitment against the post of library assistant was selected for such selected for appointment against the said post in pursuance to a selection held after the issuance of the said advertisement. The said post was so advertised by denoting the same to be so placed against roster point number 1, and further the post was reserved for PWD candidate. In the present petition, the director of FFSO, in respect of the selection of the petitioner, the same was not approved by the director of Higher Education Assam on the ground that the roster point number 1 as assigned for the said post in the advertisement dated 19/5/20 was held to have been so erroneously assigned, and the determination of the said roster point was held to have been so made without rotating the roster point in accordance with the model roster for posts having cadre strength up to 13 posts as set out in the appendix to Annex F2 of the office memorandum dated 2/7/1997. Also, admittedly, a variance is found in the roster registers prepared by the college authorities prior to the issuance of the advertisement in question, and the roster register so relied upon for the purpose of re-advertising the post of library assistant by issuance of an advertisement dated 21/6/2020. The said aspect of the matter need not detain this court inasmuch as the very eligibility of the petitioner hearing for being appointed as against the post of library assistant in pursuance to the advertisement dated 19/5/2022 is questioned by the respondents by projecting that he cannot be treated to be a person with benchmark disability and accordingly would not be entitled to be so appointed against a post reserved for a PWD candidate. Also, the term person with benchmark disability is defined under the provisions of section 2 bracketed R of the Rights of Person with Disabilities Act 2016. The said description, definition being relevant is extracted here in below. Page 5, wrong flag, sir. Automote, A2A. Definitions, huh? A2A. Begini pura. Episode R. B2B by Twitch. A perusal of the set definition of person with benchmark disability would reveal that such a person would reveal that it means it is in relation to a person having not less than 40% of specified disability. The petitioner herein is projected to be having hearing impairment. Also, accordingly, hearing impairment. Also, Section 34 of the Act of 2016 being relevant. Section 34, subsection 1 of Section 34 of the Act of 2016 being relevant. The same is extracted here in below. C2C, page 92. A perusal of the set of the provisions of Section 34 would reveal that it is mandated therein that every appropriate government shall appoint in every government establishment, not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled up with persons with benchmark disabilities. Accordingly, for being considered for appointment against a post reserved for a post identified to be so filled up by a PWD candidate, the intending candidate must possess the benchmark disability. That is, benchmark disability, that is, having not less than 40% of the specified disability. In the present case, the petitioner is found to, after the name of the petitioner was recommended by the governing body of the college to the Director of Higher Education, seeking approval of the authority for effecting appointment in respect of the petitioner here, as per the procedure put in place, the petitioner and other recommendees of and other candidates recommended by various provincialized colleges for appointment against posts reserved for PWD candidates, were directed to appear before a medical board constituted in the Gauhati Medical College and Hospital. The petitioner accordingly appeared before the said medical board on 10/6/2023. The medical board, upon examining the petitioner, submitted its report with regard to the extent of disability suffered by the petitioner, and it was noted that the petitioner suffered disability to the extent of 23% only. Where is your name here? In page 101 to?
In the writ petition, my name is at serial number 27, page 62.
That is the medical board's report.
Yes. That is the list of candidates who appeared.
Hmm.
Serial number 27 at page 98. There also it appeared. Then
23%. Also. The affidavit filed by the, from the affidavit filed by the respondent number 2 and 3 and 4, this court finds that therein a report of the district standing medical board was brought on record. A perusal of the said report with pertaining to the examination made of the disability, extent of disability suffered by the petition, it is found that the said board had opined that the petitioner has mild hearing loss in his right ear, and mild to moderate hearing loss in his left ear. The total disability of the petitioner was highlighted to be 10%. So, as noticed herein above, for being appointed against a post reserved for PWD category, the intending candidate must have 40% of the specified, must have a disability to the extent of 40% of the specified disability. Must suffer disability to the extent of 40% of the specified disability. Even if the report of the district authorities are ignored, the district selection board, district standing medical board is ignored, from the report of the doctors examining the petitioner in the Gauhati Medical College, it is seen that the disability of the petitioner was determined to be 23% only. Accordingly, the petitioner does not come within the meaning of the term, apostrophe, person with benchmark disability, and accordingly, he cannot be held to be eligible to be appointed against a post reserved for a PWD category candidate. Accordingly, it is to be noted that the said materials brought on record by the respondents, by the Director of Higher Education, as well as the respondent number 3 and 4, have not been disputed by the petitioner in the present petition. No rejoinder is seen to have been filed against the said affidavits filed by the said respondents. Accordingly, the contentions raised with regard to the extent of disability suffered by the petitioner is found to have not been disputed by the petitioner. Mr. Dr. had raised a submission, had made a submission that he having been issued with a disability certificate, and therein his disability having been so indicated, and he having been indicated to suffer. Where is your disability certificate?
I have not annexed it.
You have it?
Yes.
You have not taken a plea also in that line.
No.
Okay, now let's continue. So, in view of the above submissions, in view of the above discussion, This court having found the petition not to be eligible or being considered for appointment against opposed persons with disability, persons reserved for PWD category can, this court would not be in a position to proceed to direct the respondent appoint the of post of library assistant as advertised by the advertisement date so and so. 19/5/20. So, accordingly, the claim made by the petitioner present in this connection stands rejected. Having held the petitioner to be not eligible for being appointment against the library assistant for the reasons assigned here in comma, this court directs the college authorities to proceed with the advertisement, to take the advertisement dated 21/6/2022 issued for recruitment against the post of library assistant to its logical conclusion, and for the facilitating the said exercise, the interim directions passed by this court while the order dated 17/7/2020 stands vacated. With the above, in view of the above, accordingly, the present is held to be divided. Consequently, the same stands. However, there would be sorry, next time.
A little confusion, Millet. In the first half, that other case, Millet, was directed not to state.
No, I have not.
No,
I have
Millet.
vacated it.
Millet. Till then, he prefers an appeal before.
I have not said anything.
Millet.
But
Because
I have asked you
Yes,
not to do anything till he prefers the appeal.
because
That is an observation to the council.
yes, because that moment the post filled up by this recruitment, that cadre.
I have only given him 1 month.
Millet.
By the time it will be there. If that is be so fine, no problem.
Question is, Millet, the moment that new selection is taken.
You finish it.
Millet.
This order you will get. I don't think so. You will get it tomorrow.
Millet.
You will get it on Monday.
Millet.
Monday. You send it. You send it to director. Director is only not be sitting there for Tiagbir Hemborua College. Yes. Hundreds of colleges. It will take another 2 months.
Yes.
I have given him only 1 month.
Millet. Obvious. Obvious.
Benagmar. 45. 40 day airport. Let somebody come.
During the break hours, my lord, I have gone through the rules. I have gone through the rule 20, my lord. Small submission on that record, if my lordship allows, my lord. Rule 20, my lord, I have found that, my lord, before the may I read, my lord? For admission into the each course, the director will invite application from intending candidate, preferably by the middle of June each year, and before final selection is made for advertisement to the courses. The director will obtain a statement from each district in regard to the following. My lord, we can skip 1, 2, 3, 4, 5 is the reservation criteria, my lord. The reserve vacancy and backlog position regarding the scheduled tribes, plain tribes, caste and other backward classes. The districts and subdivisions, and in making the final selection, the director will pay due regard to the need of the districts. So now, my lord, here is the before the final selection is made. Now, my lord, once we participated, select list is prepared. Then, my lord, by applying the provision of the reservation, we were ousted, my lord. So if we
That is what the director is to do. That selection list is
My
the
lord.
final selection list that you have read now, last portion. He will give due consideration to the set position while the select list is
My lord.
prepared. Select list is for training. He will have to give a consideration to the need there. Or unfortunately, that is the provision in the right wrong, it's a different thing.
That is
Because if I say this rule is not proper, your very recruitment or your very claim for undergoing 6 months recorders class course training will go. It will be open for all.
My lord.
Mr. Bhuya, I'm not in a rush. If you want to have some more deep introspection, it will be good for me. Because I intend to
My lord.
now distinguish those two judges. I'll do that.
Then, my lord, one last option, I'll go through further, my lord, if we can add, supplement, my lord.
After making his submissions at length, Mr.
But my lord may keep it as a part heard, my lord.
I'm not releasing it after spending so much time.
My lord,
Mr. A.R. Bhuya, learned senior counsel appearing for the petitioners, submit that the matter be taken up on on 12/6/2026 at 2 p.m.
My lord.
Yes, 2 p.m. First, to enable him further examine the provisions of the Assam Survey and Settlement Training Center rules 1992.
2 million.
Prayer is not objected to by Mr. J. Handiki, Standing Council of Revenue and Disaster. Accordingly, registry to matter again 12/6/2026 for further hearing.
Obliged, diplomas.
Simple matter. Yes. Withdrawal of resignation.
Huh?
Withdrawal of resignation. Resignation submitted.
Resignation submitted after 11 days, he wants to withdraw, and that too after resignation with a 3-month notice.
3-month notice.
None appears for the petition on call. Mr. A. Ganguly, learned counsel. Learned, you're not standing counsel.
I'm standing counsel now.
Standing counsel, Assam Gramin Vikas Bank is present. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to consider his prayer for withdrawal of his resignation and for permitting him to resume his services. Also, the petitioner in the present writ petition on being issued with a order of transferring him to Golaghat region of the bank. Also, the petitioner hearing, who was an employee of the Assam Gramin Vikas Bank. Oh, he is, by the time it was merged, na?
Yes.
It is Assam Gramin Vikas Bank which has done all this.
Now, my lords, it is the Assam Gramin Bank. Vikas is out.
Out, okay.
Vikas
Assam-
is still being done, but Vikas word is out of it.
Same organization.
Lordship, same.
So it was Vikas Bank or Vikas
No,
Gramin. Now
it's-
it's Vikas
This
Gramin.
nomenclature has just come in recently.
Uh, employee of Assam Gramin Vikas Bank, bracket now Assam Gramin Bank,
Gramin.
bracket over. On being transferred in the month of February 2022, Golaghat region and the Golaghat region, posting him to Rajagaon Bank branch, which was projected to be around 155 kilometers from his home and situated in a remote area. The petitioner had approached the respondent authorities, praying for cancellation of the said order of transfer. So the respondent authorities, having not entertained the prayer of the petitioner, the petitioner, white communication dated 28/7/2020, proceeded to submit a notice, proceeded to intimate the respondents that he would not be continuing in his services with effect from 31/10/2020 due to personal health issues and unavoidable family responsibilities. The said letter communication was so issued, invoking the provisions of clause 10.1 bracketed B of the Assam Gramin Vikas Bank Service Regulation Act 2010. From the respondent authorities, on receipt of the said application notice from the petitioner, processed the same, and while communication dated 2010/2020, the petitioner was directed to appear for an exit interview scheduled on 21/10/2020 in connection with exit interview on 21/10/20. In the said communication, it was further highlighted that the competent authority of the bank had accepted his resignation. Thereafter, while communication dated 22/10/2020, the regional manager of the bank intimated the branch head of AG of the bank, Rajagaon branch of the bank, that the competent authority had accepted the resignation of the petitioner, however, subject to the condition that no liability should remain unrealized before release of the petitioner from the bank, and the petitioner is to surrender his bank identity card if issued and his health card, bank identity card and health card if so issued. The branch head was also required to advise to issue formal release order to the petitioner on fulfillment of the above conditions on or after 31/10/2020. Accordingly, the branch head, on completion of the procedure as mandated in the communication dated 22/10/2020, proceeded to release the petitioner, and the same was communicated to the regional manager of the bank by the branch head while a communication dated 31/10/2020. In the said communication, it was highlighted that the petitioner was released from the bank at the end of business hours after surrender of his bank identity card and health cards. It was also highlighted that it was also certified therein that the petitioner had no liability in the bank as on 31/10/2020. Also, the resignation of the petitioner accordingly is found to have been accepted. After the acceptance of the petitioner's resignation by the competent authority and his consequential release from the services of the bank effected on 31/10/2020, the petitioner submitted a representation dated 12/11/2020 to the regional manager of the Golaghat regional office of the bank to revoke the release of revoke the release of the petitioner from his services in the bank and to grant another opportunity to him to continuously serve the organization. The said representation was followed by further communications. However, the withdrawal of the however, the respondent bank had not accepted the prayer of the petitioner for withdrawal of his resignation. Also, in the affidavit filed by the respondent bank, it was highlighted that the resignation of the petitioner was in pursuance to a 3-month notice issued by him in the matter. The petitioner was accordingly, the matter was processed and the competent authority having accepted the resignation of the petitioner and he being subsequently released from the services of the bank, it was projected that the resignation having been effected, the same was not permissible to be withdrawn. I have heard Mr. A. Ganguly, learned counsel for the petitioner, for the respondent bank. Mr. Ganguly has reiterated the contentions raised by the respondent bank in the affidavit. Also, from the above, I have heard on a perusal of the materials brought on record, this court finds that the petitioner had duly submitted without any conditions being attached thereto a notice intimating the respondent, a notice dated notice on 28/7/2020 intimating the bank, competent authority of the bank, that he shall not be continuing in his services after 3 months from the date of 3 months or 90 days with effect from 1/8/2020. It was further stipulated that he shall be not continuing in his services effectively with effect from 31/10/2020 due to personal health issues and unavoidable family problems. As noticed herein above, the said notice submitted by the petitioner was processed by the respondent, by the authorities of the respondent bank, and the same on being accepted by the competent authority of the bank, steps were initiated for release of the petitioner. Accordingly, the petitioner is found to have been released from the services of the bank in acceptance of his resignation with effect from 31/10/2020. It is only after the acceptance of the resignation of the petitioner and his consequential release from the bank services bank that the petitioner had submitted representations for revoking his release from the bank and for permitting him to continue in it. It is a settled position of law that a resignation submitted would be permissible to be so withdrawn only till the same is accepted by the competent authority when such acceptance is mandated. In the case on hand, the petitioner having in the case on hand, from the materials brought on record, the resignation of the petitioner was mandated to be accepted by the competent authority before the same could be said to have come into effect. The competent authority having accepted the resignation and the petitioner not found to have withdrawn his such resignation before its acceptance by the competent authority, comma, this court is of the considered view that the subsequent application submitted by the petitioner for withdrawal or for resumption of his for resumption by him of in his services, for resumption of his services would not mandate any acceptance, and accordingly the bank authorities had not committed any error even in not considering the said representations preferred by the petitioner. So this court, in view of the above discussions, hold that the resignation of the petitioner had become effective on the same being accepted by the competent authority, and thereafter on the petitioner being released from his services with effect from 31/10/2020. Accordingly, the claim made by the petitioner in the present would not mandate an acceptance, and accordingly, would not mandate any acceptance, and the same stands rejected. The present writ petition is held to be devoid of any merit, and accordingly, the same stands dismissed. However, there would be no order.
Obliged.
Record.
My lord.
Record.
Record not put.
You have your records? No.
No, my lord. I have filed my affidavit, my lord.
Okay.
Termination.
Yes, Mr. Ho.
Immediately, my lord, there is a delay in preferring appeal, my lord. But that delay, my lord, was due to his illness, my lord. That is the ground, my lord.
Show me that you were so ill that all your family members, everybody should have been in the hospital. Nobody was free to inform the authorities. You say your wife had informed.
Yes,
Where is the communication? When did she go to inform?
My lord, that was also in the year 2017, my lord.
17.
Yes, my lord.
Sorry.
They preferred appeal in the year 2018.
On 3/2017,
Terminated
7
the year 13.
3/2017, my lord.
Now you have not denied two things. One, the show cause notice was issued to you. You have not denied receipt.
My lord.
Enquiry officer required you to come and appear in the inquiry. You have not denied. Three, the inquiry report was sent to you. You have not denied.
Yeah, my lord. Appeal also, my lord, there is no such ground was taken, my lord.
So you refrained from appearing. देखा जाएगा पीछे. And they also देखा दिया. Can't help it.
My lord.
Very
Yes, sir.
casual manner you have taken.
Yes, sir.
And what are the ailments? You are having a backache.
Yes, sir. Like
Oh, that we suffer daily.
Yes.
Huh.
My lord, one hypertension on
Hypertension is normal.
One anemia and
Stamlo, tablet. Stamlo. I found somewhere. Vertin. And this treatment, you could have had it in your composite hospital. CRPF?
Yes, yes.
You can have best treatment there. Why did you not go? Where were you posted at that point of time? Calcutta.
Jharkhand, my lord.
Jharkhand. And how did you file this writ petition here?
Decisions.
Huh? No order was passed.
Yes, my lord. One order.
Only thing, you are a resident here.
Yes.
Will not be of any use because, okay, we'll ignore that.
Last divisional order was passed, my lord, by the Inspector General Police Northeast Sector Center Reserve Police Force, Shillong, my lord.
Appeal to
Page 46.
Hmm.
The appeal also preferred before the Gauhati, my lord. DSCP Gauhati.
Okay, we are ignoring that. Tell me.
That's
Yeah,
my case, my lord. In
it's
fact, my
not
lord,
a
they are-
case of no
they are the
notice.
delay, my lord.
There is no, it's not a case of no notice. You have been given notice.
Yes, because from this communications, my lord, it was there, my lord. So I don't find any fault on the part of the respondent, my lord. Because in this, he sent every letter, my lord.
Okay, we are dismissing him. Nothing is here.
Only thing is that, my lord,
Yes.
if petitioner is given a chance, my lord, to approach the
he has-
requirement, that's really.
Earlier also, he has allegation of overstatement in the year 2007, 21 days,
those are
2000,
Oh,
2009, 70 days,
Those are
107 days in
that is fine.
2010.
That was used as
The habituate money of
only to
Habits
determine the.
offend, not offender.
We'll pass the orders. Let her, she has already taken one,
My lord,
big one. So next one comes, I'll pass this
my
order.
lord.
But next dialogue.
Apply.
Yeah, Mati. Next, Agole Mata.
Oblige me.
This has not been revised thereafter.
Normal. That's I think fresh notification is being issued.
Issued.
I'm told is being issued.
We are not, there is
But
none here from the last date also.
But the petition is
None
misconceived.
appears for the petitioner on call. Mr. P.K. Roy, learned senior advocate, assisted by Ms. A. Chakraborty, learned counsel, appears for the respondent number 7. 7. Additional central, that one, na? PF commissioner. So the petitioner in the present writ petition has prayed for a revision of the pension received by her from the employees provident fund authorities, right?
Yes.
Provident fund authorities. So Mr. P.K. Roy, learned counsel, has submitted that the petitioner was initially authorized a pension of rupees 708 per month, which was thereafter revised to 83164. He submits that in pursuance to the Employees Pension bracket Second Amendment bracket over Scheme 2014, the pension of the petitioner was enhanced. Family pension received by the petitioner was enhanced to rupees 1,000 with effect from September 2014. And the amount was so credited in her account with effect from October 2014, and the same is being continued to be paid to the petitioner. He submits that there be no further enhancement ordered, an enhancement made in the pension to be paid to such category of persons, after the Amendment Act of Amendment Scheme, amendment effected in the scheme in the year 2014. The respondent number 7 is not in a position to enhance the pension of the petitioner. However, he submits that as and when a further enhancement would be made effective, the said benefit would be released to the, would be authorized to the petitioner and credited to her account. So, in view of the above position, this court is of the considered view that the enhancement of the pension would depend upon the competent authority enhancing the pension from time to time, and the present enhancement being only to the extent of rupees 1,000 in respect of the petitioner. The petitioner at this stage cannot claim any further amount as pension. However, it is directed that the respondent authorities, however, it is directed that in the event of any enhancement occasioning in future with regard to the pension received by the petitioner, the respondent authorities shall authorize the same to the petitioner and credit the amount involved in her bank account. With the above observations and directions, the this. Why are you here? Why were you here? You should have been here. This is not the forum.
Lordship, my service has been utilized by.
Be that as it may, that also you will have to go to the forum you had gone first. This is not the court. I can't confer jurisdiction to myself. You're a postal employee.
Yes, sir.
When that incident happened, you went to CAT.
Yes, sir.
High Court Division Bench,
Yes.
Supreme Court.
Supreme Court, sir.
Supreme Court dismissed.
Yes, sir.
You are out.
Out.
Now a period is payment is there. You will go there, not here. We can't entertain this. L. Chandra Kumar, 3Q, Section 14.
Liberty may be granted, Lordship. I will request.
Mr.
D. Kolita.
D.
D. Kolita, Lordship.
D. Kolita, Learned Counsel for the petition, submits that he may be permitted to heard Mr. D. Kolita, Learned Counsel for the petitioner, also heard Mr.
B. Deca,
B. Deca, Learned CGC appearing for the respondents. Mr. B. Deca at the outset had raised a order same order, my dear. Has raised an objection with regard to the has raised a preliminary objection with regard to the has raised an objection with regard to the maintainability of the present petition. Mr. Deca submits that the petitioner is an employee of the postal department, and accordingly, the present petition would not be maintainable before this court at the first instance, and the petitioner is required to approach the Central Administrative Tribunal, Gauhati bench, for redressal of his grievances. Mr. D. Kolita, Learned Counsel, Baki Hinipa Mairi. Dismissed.
Deeply obliged.
Obliged, Lordship.
I'll give you liberty.
Lordship.
That period.
Obliged.
Right, please, Lordship. My lord, for the Ellis Commission of my lord, breach of discipline and misconduct, my lord, initially the petitioner was my lord suspended, my lord, and subsequently my lord departmental proceeding has been initiated, my lord. And in the departmental proceeding, my lord, penalty was imposed, my lord, that is removal from service, my lord. And against that order, my lord, I have prepared an appeal before the appeal.
What happened? That criminal petition is still pending.
Criminal revision
is still pending.
Lordship.
State, all state.
State.
Yes.
Lordship,
one will come into operation only when a conviction is there. The conviction is state. And you're not releasing to him anything. Even if we hold that it is conviction, 1/3 he gets. Why these things are not being given?
Lordship, my senior is conducting this case. My senior is on his way. He will be.
Okay. Yes, Mr. Board, you can continue.
Lordship, my lord, now, my lord, from the my pension has not been paid, my lord. And so far, my lord, section 40 is concerned, my lord.
You have the regulations with you?
Lordship, my lord, section 40, my lord. The general condition, my lord, I have a copy, my lord. May I forward this copy, my lord?
There is no order passed withholding your pension. Any order passed withholding?
No order has been passed.
Lordship.
Okay, we'll take it up. There you go. Who is your senior?
Mr. S. Doctor.
Oh, there you go. Mr. Das, you are waiting for that. It's coming. It's coming. There. None appears for the parties on call. In the present petition, the petitioner has raised a grievance with regard to a recruitment exercise carried out. Recruitment exercise carried out by the respondents for recruitment to the post of Constable General Duty in Central Armed Police Forces, bracketed CAPFS, PF Horus, bracket, NIA, and Roman and SSF, and Rifleman, bracket GD in Assam Rifles, bracket AR examination. The petition projects in the writ petition that he had cleared all the stages of the selection process and had secured marks above the cutoff marks. However, the respondent authorities, although at this stage, at the time of conducting the detailed medical examination, had not rejected the case of the petition, subsequently, the case of the petitioner. How subsequently, while publishing the select list, the name of the petitioner was not incorporated, and on inquiry, he was given to understand that he was declared unfit in the detailed medical examination. The petitioner had prayed for a review medical examination for a direction upon the respondent authorities for carrying out a review medical examination in the matter. The selection is of the year was initiated in the year 2018, and the select list was published in the year 2021. Considering the long lapse of time occasioning in the matter, and also the nature of the relief sought for in the present petition, this court is of the considered view that the petitioner in the meantime may have been accommodated, this court, considering the non-representation of the petitioner in the matter, presumes that the petitioner has been employed in some other service. Accordingly, the present petition stands dismissed for not dismissed it on merit. They want to come back, let them come. Yes, Mr. Dotto, what is this you're doing? What is your bank doing? There is no conviction in him not today.
No,
You have not passed an order.
But your lordship, the conviction.
Conviction is stayed.
Has been
Stayed
stayed.
means stayed. Everything is stayed.
But we are awaiting for the entire.
How long? How will the man suffer tomorrow? The court allows it. What will happen? At least 1/3 you could have given him. Why have you not given him? With interest, 1/3 now. What interest do you take for loans these days?
7%.
7? No.
8%.
No, more than that. So 1% above that. Give him.
I'll take instructions if it can be.
Mr. S. Dr. Learned Counsel appearing for the respondent bank shall apprise this court as to why the petitioner was not released his pension and pensionary benefits, although the conviction of the petitioner is under stay in a proceeding pending before this court. Further, the provisions of Rule 41 mandates that a minimum pension, even in case of dismissal from service on account of conviction, is required to be so authorized. The same is also not found to be authorized to the petitioner. Mr. Dotto shall apprise this court as to why this court shall not pass orders directing the authorization of pension to the petitioner at the minimum rate, at the minimum stage, with imposition of interest at a rate to be decided. Also, raised it to list this matter again. Kundinapari. 12/6/2026 for further hearing. Mr. Borwa, let's see what happens. But your conduct is also not good.
Subsequently, my lord,
Your conduct is also not good. The appellate court took a very lenient view in your case. That as it. You have borrowed money. We'll consider.
obliged.
No, madam, it's
Receipt?
for mediation, madam. No, not this. Everything received except the leave encashment. And
My lord, I have one communication. This is the last communication from the authority. On the basis of that, court can dispose of the matter.
Except the leave encashment, everything. is done.
Pension, gratuity,
Everything, everything, only the leave encashment.
Some department proceeding is pending as per this communication.
Ms. A. Gayan, learned, Mr. S. Bora, learned counsel for the petitioner, states that all the other retirement benefits has been released to the petitioner, including his monthly pension. However, the leave encashment benefits are yet to be authorized to him. Ms. A. Gayan shall apprise this court shall receive instructions and apprise this court on the next date of listing as to why the leave encashment benefits have not been released to the petitioner. Ms. Gayan shall also apprise this court the officials who are responsible for the delay occasioning in the release of the leave encashment benefits to the petitioner, so as to inasmuch as this court would consider imposition of interest on account of the delayed payment of leave encashment benefits to the petitioner, and the said amount would be required to be recovered from such erring officials. Registry to list this matter again on
Some time maybe
17/6/2026
17,
for
but
further any ahead
17th is my lord. Can it be on 23, 24, my lord?
23
Yes, my
23
lord.
for further hearing.
Yes, my lord. Sorry, no problem.
Now you get. No, we passed these orders against Mr. Bora daily. So sometimes we should give him also. No?
Wait, please, my lord. My lord, this is a case where petitioner's husband expired. He was a
17.
Yes, 17, and he
DLC twice recommended.
Yes, yes.
SLC then rejected.
Rejected, saying that the 5% quota was already filled up.
So that 2 years period limit is over. So what more is left?
No, my lord, this is a case where the petitioner left behind two daughters, one 7-month-old and one 4-year-old. And the DLC had recommended.
No compassion is coming out. 2017. No compassion.
I mean, my lord, if we.
Sorry. I've been consistent in one thing. This one. You can test it.
No, my
I'm
lord,
sorry. This is not maintainable. 2-year limit. 2015. You have the 2015 circular.
No, my lord.
Achut Ranjan Das, my lord Justice Gogoi's order. Last clause.
Yes.
That if an application is pending for 2 years for want of vacancy, it has lost its will.
No, lordship.
And that was copy pasted by the respondents in that decision, in that office memorandum of 2015.
2015. First June 2015.
Right, my lordship, just 1 minute, I'll just submit and then.
Right, 1 minute, you take 1 hour, no problem.
No, I'll not.
But the end result would be this.
No, lordship, first of all, Achut Ranjan Das's judgment, it was most not followed by the state itself. No, lordship knows that, because within the time limit that placing before the DLC and within time they'll have to place before the SLC. First of all, that time limit was never followed. And secondly, lordship, if we are talking about the 2015 office memorandum, which the SLC also in their first page that which I have annexed in page 48, they say that they have considered as per 2015 office memorandum. This is one of their observation. But when we see page 50, where our rejection is there, lordship, we do not see that the paragraph 15 of the OM that had been considered. They could have considered it, because this is one of the fittest case, lordship, because even today, if we consider that 4-month-old girl plus say 9 years, whether financial condition has changed, it has changed for worse, not better. Because she will be 9 years and 4 months. That's all. So if in this situation, if they have taken 2015 OM into consideration, then why not para 15 of this as well? That if in particular office there is no vacancy, they can look for vacancy at least in some other. And DLC had recommended twice. I mean, they know the ground reality. What was the situation? So this only, Lordship, this is, and it,
Debabrata Tiwari, Supreme Court. You say Achyut Ranjan Das was not followed by the respondents. But that decision is binding on me. I'll have to follow it.
yes. No, Lordship, I understand. This is the situation, but Lordship had also passed, I think, orders, which I have seen, of course, I have not brought, wherein some kind of at least some monetary compensation was also.
When was the date of death?
It was on. No. Oh, yes, 13/1/2017 was the date of death.
Nothing can be done. Retrospective effect. No, that is forget it. But what about that 1/4/2017 thing? CPF. That cannot be given. End of the day, you are making me emotional. I can't be emotional. I'm a judge.
But Lordship, the thing is, I have heard somewhere that we should not only place case law. If the judge is happy on the facts, the court may find case laws.
I don't like to be
not
bogged
happy,
down by
satisfied.
case laws. I like to the facts
Yes,
revealing
yes.
the
So that's what I have told.
I'm sorry.
That is the fact.
We'll try next time in your case. But Mr.
MK Chaudhary.
L.
MK Chaudhary.
L.
MK Chaudhary.
MK Chaudhary, Learned Counsel for the petition. It is because you are here. If the senior was here, I would not have heard you him even for this much.
Yes.
The petitioner in the present petition has prayed for a direction upon the respondent authorities to set aside the minute decision of the state level committee. A decision arrived at in respect of the claim of the petitioner for appointment of compassionate grounds by the state level committee in its meeting held on 27/11/2020. Also, the petitioner has made a further prayer for a direction upon the respondent authorities to consider her case afresh for appointment on compassionate grounds. Also, as projected in the petition, the husband of the petition, Pinu Talukda, while working as a chain man in the establishment of the settlement officer, Karimganj, had died in harness on 13/1/2017. Also, the petitioner, being the wife of a petitioner, thereafter, the petitioner proximate to the time of death of her husband had submitted applications before the competent authority of the department for consideration of her case on compassionate grounds. So the application submitted by the petitioner is found to have been placed before the jurisdictional district level committee in its meeting held on 17/7/2017. The jurisdictional district level committee, after considering the claim, after considering the said application submitted by the applicant, by the petitioner, and on verification of the particulars therein, recommended the claim of the petitioner for appointment against a vacant post of chairman, grade 4 post, grade 4 post, available for the during the year 2017. Also, the case of the petitioner was again placed before the jurisdictional district level committee in its meeting held on 16/12/2019. Also, the selection committee, upon examining the matter, was again placed before the district level committee inasmuch as the settlement officer Karimganj had submitted that certain obligatory information like financial status, vacancy position, as per the norms of the 5% quota, as per the guidelines for appointment under 5% against 5% quota for compassionate grounds was not placed. Also, further, it was projected that there was a discrepancy in the name of the husband of the petitioner. Also, the jurisdictional DLC again examined the matters and arrived at a decision that and on rectifying the earlier the deficiencies noticed, again proceeded to recommend the case of the petitioner for appointment on compassionate grounds and required submission of a proposal for before the state level committee. So the petitioner's case was thereafter placed before the state level committee in its meeting held on 27/11/2020. The said committee on recommending the case on examining the case of the petitioner in the light of the recommendations made in her favor by the jurisdictional district level committee proceeded to reject the claim of the petitioner by holding that two posts identified for appointment on compassionate grounds which fell within the 5% of the cadre strength permissible for appointment on compassionate grounds were already filled up. The petitioner, being aggrieved, has instituted the present writ petition. Also, the learned counsel for the petitioner has, by reiterating the facts noticed herein above, emphasized that the financial condition of the petitioner's family has deteriorated further since the death of the only bread earner in the family, that is the husband of the petitioner herein. Accordingly, he submits that the petitioner, even as on date, is in need of an appointment on compassionate grounds so as to lead a dignified life. Also, per contra, Ms. M. Bhattacharjee, learned counsel for the petitioner, by referring to the office memorandum dated 1/6/2015, has submitted that the application submitted by the petitioner having remained without the same being translated into an appointment on compassionate grounds, for more than 2 years, in terms of the principle laid down by this court in the case of Achyut Ranjan Das versus State of Assam, judgment asylum, and more particularly, and further, in terms of the provisions of the office memorandum dated 1/6/2015, the case of the petitioner would not mandate a further consideration. She submits that although the recommendations were made by the jurisdictional district level committee, such recommendations were not made along with the identification of the post against which the petitioner could have been so appointed. The available vacant post being already utilized, the identified vacant posts within the 5% quota prescribed for appointment on compassionate grounds having been already utilized by appointing persons on compassionate grounds earlier, there being no further vacancy available, the case of the petition would not mandate a further direction for appointment on was rightly rejected by the state level committee. Also, she submits that considering the long lapse of delay, the long delay occasioning in the matter, long lapse of time occasioning in the matter after the death of the husband of the petitioner, the following the decision of the Honorable Supreme Court in the case of State of West Bengal, the Parvine, Devabroto Tiwari, reported in so and so. The petitioner would not, a direction for an a fresh consideration of the case of the petitioner would not be mandated to be issued by this court. I've heard the learned counsel for the parties and perused the materials available on record. It is seen that the petitioner, pursuant to the death of her husband, had submitted which had occasioned on 13/1/2017, had submitted an application for consideration of a case for appointment on compassionate grounds. The application submitted by the petitioner was considered by the jurisdictional district level committee in its meeting held on 17/7/2017. Also, this court on perusal of the recommendations made by the jurisdictional district level committee in favor of the petitioner, does not find that the said recommendation was made against a specific identified vacant post within the 5% quota mandated for appointment on compassionate grounds. After the said aspect of the matter was again highlighted by the departmental authorities before the district level committee, the district level committee in its subsequent meeting held on 16/12/2019 had again considered the case application submitted by the petitioner, and on such consideration had again proceeded to recommend her name for appointment on compassionate grounds. However, this court finds that even in the second meeting, even in the second round of consideration of the claim of the petition hearing, no vacant post was identified for the purpose of appointment of the petitioner. It is
actually in page 31, a vacant post of chairman is identified.
Chairman, it should be within 5%. That is the problem. Not there. 5 vacant posts within 5% of the quota mandated for appointment on compassionate grounds was identified. So this court has thereafter perused the minutes of the meeting of the state level selection committee held on 27/11/2020, and on a perusal of the conclusions reached by it with regard to the claim of the petitioner, this court finds that the rejection of the claim of the petitioner was on the ground that 2 posts which were identified for appointment on compassionate grounds in the establishment concerned was already filled up by appointing persons found eligible for appointment on compassionate grounds, and there was no further vacant post within the 5% quota mandated for appointment on compassionate grounds. This court, on a perusal of the said conclusions drawn by the state level committee, finds the same to be not erroneous. Further, the petitioner has not brought on record any material to dispute the conclusions reached by the state level committee in the matter. So accordingly, the conclusions drawn by the decision arrived at by the state level committee in the considered view of this court would not mandate any interference. Having drawn the said conclusions, this court would now consider the claim of the prayer of the petitioner that a direction be issued upon the respondent authorities for consideration of a case for appointment on for a fresh consideration of a case for appointment on compassionate grounds. Also, as noticed here in above, the husband of the petitioner had died in harness on 13/1/2017. Around more than 9 years have lapsed since the date of death of a husband of the petitioner. Also, considering Baki, my DB, Devabroto, taking okay. This was
Obligation.
Yeah. Oh, it too.
Made please your worship.
Here is a tracer, my lord. In his case, earlier.
Ms. Chaudhary, 2 minutes. Please have your seat. 2 minutes. Give me just 2 minutes. Yeah, madam.
May it please, your lordship.
Yes.
Yes, my lord.
Yes.
My lord.
Done. Wait.
No, my lord, we are yet to, means the thing is that almost 17 years this writ petitioner was on and off. He was absent from service. Last 6 years he did not
You
come.
have regularized his services as UL.
Yes, my lord, almost 17 years. That is what
we are not concerned for that 17 years. But in 2016, you have regularized his services.
Then when from 2016 to 2022, again he did not come.
No, he has not come. What is the proceeding you have done? Wrong.
No, my lord, we haven't done.
When is he retiring, Ms. Chaudhary?
No, he has retired.
He has already
22
attained the
retired.
age of superintendent.
And nothing
He retired without coming to office. 16 to 22 again he absent.
Where is that
Absent, my lord.
person order that this period will not get this period, no work, no pay? And you have this matter is pending from 21 daily adjournment.
My lord will fix the matter next Tuesday.
Other than that, we have been doing nothing.
No, my lord.
You get your secretary, everybody here. We'll see what can be done.
Tuesday, my lord will fix. This Tuesday, my lord. By Monday, I will file an affidavit and then my lord will on Tuesday dispose this case.
Here, serious objection.
My lord, then on this written instructions, I have my lord will dispose of this matter. But my lord, what to do? Means this is a petitioner, my lord.
See, if I have to dispose it the matter in this stage, I will give him full benefit. I am restraining myself because I get a smell that this man has not worked. But you are not supporting. Mr. Ad hoc learned counsel for the petition submits that an affidavit in the matter is ready and would be filed on 16/6/2026, 17/6/2026. Registry to list this matter again on 18/6/2026. In the event the affidavit is not on record, the executive engineer, PWD, Gauhati Building Division 1, along with the chief engineer, PWD Building Assam, Gauhati, Chanmari, and the commissioner and special secretary, PWD Building, Chanmari, shall remain personally present before this court, along with the contemporaneous records for assisting this court in disposal of the writ petition. Three authorities are the top authorities.
Well,
executive will put up a note here only. Chief will forward. The commission secretary will sign. Either it will be an order giving her or not giving. No more further adjournment. Okay, I'll give you some more time. Iman tarik dilu mai 16 question 18. Mikwa affidavit by 18 aru listing by 22.
18.
Thor is a busy man, we know that.
No, my lord, it is. I apologize, my lord, for the department also, my lord.
No? We know how to get it done. Don't worry.
My lord.
You move out from the way, we will deal with them directly.
Problem, my lord.
Till you are there, they are safe.
My lord.
And tell them, if that situation comes in, matter is before me, cost would be exemplary. Ms. Chaudhary, you also help me assist how you can best.
Please, Your Lordship.
You have got the division bench order?
Yes, Lordship.
Give me the particulars. When did your father die? 16/1.
16/1/2016.
And his retirement date was? Where is the rejection for that 3-year residual period? Any material on record?
152, Lordship. Page 152. Point 1, Lordship.
Disposal. Mr. Das, I'm sorry I kept you waiting, but
it's our duty.
There are many old matters, means these are just pending. People are coming, going. So I'm trying to.
I would like to help your lordship by putting the list of dates and submission. And that will also.
No, we wanted to hear the AG today.
They have given one affidavit. Affidavit says malaria is less. Now there is no less malaria now. We have given the charge to them. But what I was trying to ask your lordship is that in view of that Gill case, Mohandar Singh Gill case, can they come out from the impugn order? Impugn order says because of the Uma Devi, our regularization is not done. That is what they say. And the sad part of the whole thing is that, my lord, after after their extension, last extension order, they walked. I've given document. They have not denied it, but they said
When say now,
they don't
Upendas is also, Mr. Das.
some way is there.
No,
but
Upendas is gone. It has been set
no,
aside by
Upendas
the,
has been set aside.
set aside by.
That has been set aside.
So now the question is regularization is to be considered.
Upendas, my lord, they have given full relief,
100%.
including pension, including
Beautiful.
pension, etc. So that should be, I mean, now our court will also rise, hopefully, my lord. I have done one.
No, babe. See,
Good,
there
this-
are
this-
some restrictions. Now that restrictions have been removed. You give me a date, Mr. Das. Give me a date. Today, so it's not possible.
Tuesday, my lord, next Tuesday.
And my hands are all tied up.
ठीक हो रहा है।
They have enough work for the night for whole day now.
The Sukanto Bhattacharya's case, it has taken into consideration all the
Everything it has. Yes, Mr. Bora.
Possible. Can it be fixed on the coming Thursday, my lord?
Will be after vacations.
Because now the paucity of time.
Because last week,
yes,
is motion day. So we can't take up hearing on that day. Next week, 2 weeks, I think I have. Kundina pani aseni. Huh? No, Juno. Weekdays or no? 24 no, last week or a motion week. Ta got 9, na? Right over. Good do? Good do, buddy.
What I was proposing to do is, my lord, I have completed my submission.
No, I just want to hear the.
Yes, my lord, they can give written because they are positive of
No,
time.
I want to hear it.
No, AG has got positive of time. He is very busy.
No, today he was there,
He
my
have
lord.
paucity of time, but he is a person who does cases.
Does cases and he is very
And today he is waiting, my lord. But now, my lord.
May I just hand over this, your lordship? It will be very convenient. I think all the list of the.
We will hear the AG when. Tell me. We'll find out some time for them.
Next week, if
9th, 11th, no, 11 bitat kundina pari, 11 pari. 11.
Yes, my lord.
That will be the 2
11.
We'll not put it. If the AG is free, ask him to make a mention because AG gets precedence.
Yes, my lord.
We will hear him. In
Yes,
the
my
first
lord.
half.
11, my lord.
Subject to some motion, something. We
Yes, my lord.
Or should I give this now or later?
That day. Because it is here that only the formula I have to find out. That's all.
And
now with Tukendo again.
Yes, this Tukendo is.
Okay.
Yes,
their impugn order.
And
only says
when
that.
making those, just factor in that these people, even if we don't go into the whether this is to be done, not done, regularization only if we see. They being 3F appointees, admittedly they were appointed against posts.
Yes, my lord.
You get my point? So just factor in that brief, Mr. Soikia, that in that view of the matter, how should this court approach according to you? Give me. Because there are decisions of the Supreme Court, latest, that regularization not permissible if they are not working against a post. Here, you can't take that plea. They are 3F, they are against postal.
But Sripal and all, my lord, that's a different matter.
I'm taking a negative judgment.
Yes.
And therein also Supreme Court said that if they are working, then if they work for a considerable period of time, they should be.
Yes.
Another
But
factor
here
in this case.
issue is